All right, everybody, Groundhog Day. Here we are again, Thursday night. Uh, Larry and I coming to you live from the bunker here at Trumbull Regional Medical Center. We got some special guest speakers tonight. Tonight we're going to have Chief Comstock from the Western Reserve Joint Fire District. Sorry about that, Chief. He's a well-known and well-respected attorney and fire chief in the area, and he's going to be talking to us about some of the legal issues in pre-hospital EMS and hopefully try to keep us out of trouble so we don't need lawyers. And then after that, we're going to have Captain Renee Waldo, paramedic with the Vienna Township Fire Department. She's going to be talking to us about EMS documentation and, again, how to keep ourselves out of trouble, hopefully. Hopefully everybody else is having the same experience we're having here at Trumbull Regional as far as COVID goes. As of today, we have not admitted a COVID-19 patient in 8 days, and we are down to 2 in-house, which are both long haulers. So I really hope that means we're going to have as normal of a summer as we can with World War III starting in the background. Without any further ado, Chief Comstock, thank you for taking your evening with us, and the floor is yours.
Thank you very much. Hopefully everybody can hear me. If not, raise your hand or, give me some sort of signal, text me. I've seen messages. When I was asked to do this presentation, we originally talked about doing some about documentation, refusals, consent, and so forth. And one of my concerns was that will last for me about 5 or 10 minutes. I know Renee's going to expand upon a lot of the documentation needs, but I wanted to focus really on the issues that I thought you all would be more concerned about. And I started, asking people what is, the greatest concern really to the EMS provider in terms of the care and treatment that you're going to provide patients. And as I talked to a few people, it basically came down to, am I going to get sued? As we talk, as just mentioned, how do we stay out of trouble? How do you not have to visit lawyers? So I wanted to talk a little bit really and provide you with the knowledge that you're going to need when somebody says, you can get sued for this, or you can get sued for this, or you have to watch out. Where are your greatest risks? Where are your areas that maybe you don't need to be concerned? And, what are the protections that are out and available to you? So that's where I'm going to start off the presentation. We're going to talk about lawsuits. We're going to talk about immunities and try to provide Ohio's complicated laws about immunity to you in a manner that you can understand. I'm going to talk after that about consent and refusals, advanced directives. We'll talk a little bit about HIPAA, mandatory reporting. I have some miscellaneous topics I'd like to address, which are, use of guns and vests in the EMS service, ambulance staffing, social media, and particularly digital imagery on scenes and the use of that. And then if we have time, I am going to talk to you about whatever the steps that you can take to prepare yourself for testifying, actually get into the mechanics of testifying in court and what you need to do to prepare for it. If we don't have time for that, I'm doing a presentation this weekend just on testifying. We may try to do that another day and make that available for everybody. So if you run into a situation that you're faced with having to go to court, we'll talk about how to succeed in that environment. So the lawsuits, and many of you probably heard this, or when you went through the basic EMT class, talked a little bit about what is required in the lawsuit. So sort of as a refresher, the first item is a duty, and that's the duty to act and provide care and treatment to a patient. And I don't really focus on that at all, because typically if you're out providing EMS with a service and you're sent to a call, you're going to have a duty to treat that patient. Where the duty issue sometimes comes up is when you're off duty, walking down the street and somebody's in trouble, or you see an automobile accident, do you have a duty to render aid in that case? And although there are a few states that do make it mandatory for EMTs and physicians and so forth to provide care, Ohio is not one of them. And so it's really more of a moral obligation or ethical obligation as much as it is not a legal obligation. So if you're on duty, let's just assume that you had a duty, and we'll get into the next element, or again, 4 elements for a case. The second is negligence or improper conduct, and that's when we hear people talking about breach of that standard of care. you're going to have certain rules in the state of Ohio that say, or protocols that say, this is what you should be doing under these circumstances. You may have department policies and rules, regulations. And there are certainly textbooks and educational treatises out there that are going to talk about what you need to do in terms, given a certain circumstance. And if you don't do that, if you're deviating from that standard of care, that's deemed to be negligence. Now, there's different standards of negligence, or what I call improper conduct, and we're going to talk about those a little bit. And that's good. Those differentiations of the different types of misconduct are going to be very important when we get into the immunities. The next element is causation, and that's that your breach of that standard of care, falling below the standard of what you should be doing, actually caused some damage. And the last element is damages. So again, we'll move forward. As I said, we've already talked about duty, talked about negligence, again, falling below the standard of care. There are the forms of conduct other than negligence. And again, negligence is more doing something you shouldn't be doing. And I just lost my slides. I don't know if you guys can see them or not. They are not on my screen.
No, you might have to unshare and reshare, Chip. For some reason, it flickered, and I'm not sure why.
Let's see here. Share. I don't know why I'm not getting. Sorry, guys. I'll try this again. We're back.
You're back up.
All right. Sorry. All right. So when you get beyond the negligence, which is just, again, deviating from the standard of care, you could have the next, which is sort of a worse form of conduct, which is reckless conduct. The next worst behavior from that is wanton misconduct. And then you get into willful, or what's called intentional misconduct. So while we think about negligence, if I were trying to define that as just making a mistake, driving down the street and necessarily not paying attention, and the speed limit's 25 and you're doing 30, or you just somehow missed that stop sign and drove through it. It was a complete accident. You really weren't paying attention. When the conduct is I'm going to move up. Recently, and I say recently, in 2012, so 10 years ago, there was a case called Anderson versus Massillon that involved two fire engines proceeding to report of a fire in the city of Massillon, coming to a blind intersection. First truck, and I don't remember if it was the first truck or second, but long story short is they collided with a car in the intersection. The one engine did. And the occupants of that car, a grandfather and grandson, were both killed. And they sued, the estates sued the city of Massillon and claimed that they were immune. And one of the things that the court had to do, the Ohio Supreme Court had to determine, for purposes of the immunity statute, what was reckless or willful or wanton. And we'll get into those uses of those terms. But they start off by defining reckless conduct as a conscious disregard or indifference to a known obvious risk of harm to another that is unreasonable under the circumstances and is substantially greater than negligent conduct. So if I was going to define that in terms of that speed that I talked about, you're driving down a street and the speed limit's 25, you're not paying attention, you're going 30 or 35 miles an hour. Somebody may say that is negligent if you get in an accident at that speed. But if you're driving down that roadway at where the speed limit's 25 miles an hour and you're doing 50 or 75, that may be reckless. And, you know, at some point along that speed continuum, it goes from negligence to reckless. And it's going to be, unfortunately for us, it may be a jury, depending on the facts and circumstances, that have to decide, well, you know, the court can look at that and say, as a matter of law, 30 in a 25 zone is negligence, but it's not reckless. And the court could probably look and say, I'm pretty confident that 75 or 100 miles an hour in a 25 zone is reckless. But is 50 miles an hour reckless? In those cases, they may say that's I'm not sure, so I'm going to send that case to a jury. You know, again, if we're asserting immunity, and we'll see what I mean when we talk about immunity. The next is wanton misconduct, and that's the failure to exercise any care towards those or whom owed a duty, in which there's a great probability that harm will result. So here, you're really not exercising any care, and it's likely that somebody's going to be harmed from your conduct. So again, that may be driving, 75 through a school zone, because, you know, when you know kids are let out, or through a high or densely populated area. So again, as you start adding these terms, you know, this is conduct is worse than reckless, and it's considered wanton. Again, so we have negligence, reckless, wanton, and then the last definition is willful, which really is an intentional deviation from your duty. I mean, this is where you're just refusing to do something that you should do. It's likely, you know, in this case, with the knowledge or procreation, that the likelihood of resulting injury, that by you doing something or not doing this and making that conscious disregard for the safety issues, your behavior is going to be deemed willful. And one of the areas that, for purposes of driving, that this happens, people consider willful misconduct or intentional conduct, is when somebody makes a decision to drink alcohol and drive. It's not, swerving across the road, that may be negligence, but it was the intentional act of deciding to drink before you're driving that's considered willful. And the same thing would be with respect to texting. If you're driving and texting, the law said that's against the law. You've made that conscious decision to text, knowing that it's likely that will result in some injury. And so the law, when you have willful misconduct, often they will associate punitive damages with that, which means in addition to the injury damages that somebody is owed, the compensatory damages, you're going to owe damages which are aimed to punish. And I have some slides on that. So again, causation is just that your harm caused somebody some injury. If you're driving down the street and you drive through a stop sign, you didn't hit anybody, okay, you were negligent, but you didn't cause any damages. If you go through a stop sign and hit a car, and it was your fault, you likely caused property damage, you may have caused injury. In the EMS setting, again, if you failed to, outside of the driving world, if you failed to do something or did something wrong, did your act or your omission cause some injury? That's the causation issue. And often that's a basis upon which I defend cases. So in the auto accident case, I may admit that my client drove through the stop sign, and even if he hit the car, we didn't cause the injury, or we ran into the back of that car, there's a dent in the rear, and you're claiming all these injuries we don't think were medically related. In the city of Youngstown years ago, I defended the city on a multi-million-dollar case in which the building owner claimed that the fire department and the city failed to provide sufficient water to the fire department to put the fire out. And at the time, for those of you who are firefighters in the audience, when the fire was discovered, it was through the roof. There was all sorts of chemicals stored in the building, including a number of that would react to water. There was not a sprinkler system in the building. There was not a fire alarm system. The building had doors open throughout it, and the fire department got there, decided to make a defensive attack right off the bat. So when the owner sued the city saying there wasn't sufficient water in the hydrants, and there was some evidence that might be true, the argument was, okay, fine, but that lack of water did not cause your damages. The building, if it was a defensive attack and the fire was already through the roof, you weren't going to save the building. So you have to analyze cases on the issue of proximate causation to see, can you tie, or can the person who's making a claim tie their injuries to whatever the alleged acts were. If they can, they're going to try to seek damages. And typically, there's compensatory damages, which are going to be the economic damages that are, out the lost wages, funeral expenses, property damage, whatever. And then we have the non-economic damages in Ohio, which is pain and suffering. Then you'll see the term loss of consortium in most lawsuits, and that's basically loss of companionship, which may be between spouses or maybe between parents and children. You look up the word, you'll learn a whole lot, and it means other things as well. And then punitive damages are basically there to deter conduct and to punish the wrongdoer. Punitive damages are not covered by insurance. That's one of the problems for somebody who's committed that intentional act. And again, you could have that even in an assault case where somebody punches somebody else. They're going to make a claim for punitive damages, and that's where you get hit in the pocketbook because it's against public policy in Ohio to actually insure for punitive damages. So that is coming out of the pocket of the wrongdoer. All right, so we're going to talk about three types of immunities. We're going to talk about political subdivision immunity, EMS immunity, and Good Samaritan immunity. So political subdivision immunity applies to government. So anybody here who's working for a public EMS system is going to at least have some form of governmental immunity, just not for EMS, but for other things that the government may do. We'll talk about private EMS in a bit. I will say that if you're in a private fire company, that under section 9.60, and I didn't address this in my slides, but under section 9.60 of the revised code, chapter 2744 is applicable to the acts or omissions of a private fire company. So for purposes of a private fire company, you would be covered, but if you're in a for-profit EMS system, you're going to be under the EMS section. So the chapter 2744, the revised code, which is political subdivision tort liability, does not apply to contract action. So you can't order something for your EMS unit. It arrives, and then you say we're not paying the bill because we're immune from that. So this applies to basically torts, which are forms of accidents. Civil actions by employees versus the political subdivision, and matters that arise out of wages and hours, working conditions. So if there's a dispute between the employee and the employer out of the job, the tort laws don't apply, or immunity laws don't apply. And last but not least are civil claims based upon alleged violation of federal law or United States Constitution. For police officers, this means that if somebody sues them for violations of their civil rights, the tort immunity section is not going to apply. You're answerable to any alleged violation of a federal statute or the Constitution. So civil rights claims, potentially HIPAA violations, all those type of things that would be federal law, you don't get a break from. Also, with respect to motor vehicle accidents, there's an exception for motor vehicle accidents. So if you're driving a public vehicle and you get in an accident, you are responsible for the damages. There's not, and I say the political subdivision is responsible for the damages. There's not an exception except if you're en route to an emergency. Now, what's interesting to me about, and I don't know that I remembered this, but it applies to a member of a fire department emergency medical service responding to an emergency if the operation of the vehicle did not constitute willful or wanton misconduct. So again, if you're driving and you're negligent and you're running red to a call, you're going to have immunity. If you're down, you're driving that 50 to 70 miles an hour down the road in that 25 zone and it's reckless, you will not have immunity. The other distinction that I didn't realize until I was looking back over the law is that for police and firefighters, you have immunity, as I said, if it's not willful or wanton misconduct. But if you're for EMS purposes, you have to also comply with RC 451103, which says you have to stop at basically red signals, traffic control devices or stop signs. That mandate is not in the immunity section for police or fire. I have no idea why not, but the law makes a distinction of what you have to do to have that immunity on the public side. The tort immunity section 2744 also does not apply to road maintenance, physical defects in the grounds of government buildings, lack of maintenance of governmental property, or the negligence of employees that occur on the grounds of public buildings. So where does this fit into our EMS immunities? If somebody's on your property and slips or falls in a station, and you've left, there's grease on the floor, there's been water spilled and not cleaned up, you will not have immunity. So the areas that so far that I think you have to pay attention to are driving, and again, for that reckless misconduct, and for anything that might be defective on the grounds of the public building. And again, violations of federal law. It also does not apply to proprietary functions. So the Ohio defines, has two types of functions: a proprietary function and a governmental function. Governmental functions are the provision of EMS, fire, zoning, police, etc. A proprietary function is something that the government is doing as a part of a business, and that can apply to hospitals. It definitely applies to like waterworks, where they're charging, the city of Youngstown water system is charging customers and is in the business of that service. And so it will not have immunity. So they divide the codes into governmental and proprietary functions. Does not apply to proprietary functions, but again, that really doesn't affect us because we're in the EMS side of it. And then it also does not provide protection. The 2744 does not provide protection when civil liability is expressly imposed by the code. So there's a section that says if you do this, you're going to be responsible, but there's not a lot of sections that would work or would apply to us. I'm sorry. The political subdivision action, there's also a whole section just on specific immunities, and I just jotted a couple down. One is judicial or legislative functions, and they also talk about quasi-judicial or quasi-legislative functions. So judges, somebody wants to sue the prosecutor or judge, they're going to have immunity under Ohio law. They have immunity under federal law. Acts or omissions within the discretion of employee. So if the employee has a great choice of what type of action he or she wants to take, there's typically going to be immunity because the courts aren't going to second guess that employee's decision. When it comes to EMS, we don't really have that much discretion. We have our protocol. You should follow the protocol. Under the circumstances, this is what's expected. So it's not a matter of, okay, I have a couple different choices. What do I want to do here? The other thing is that comes up a lot is the decisions on the use of government assets or resources. What type of ambulance are you going to buy? Where are you going to place fire stations? Are you going to close a fire station? How many people on an ambulance? How many people on an engine? Those are decisions that the government is going to make based on what the resources are, and there's no necessarily right or wrong answer, unless there's some other statute that absolutely mandates staffing, for example, we have on ambulances. But whether you have two paramedics or a paramedic or EMT, or we're going to close this station today, that's a decision that the government body's going to make, and the courts are not going to get involved in that and try to second guess. That's not their job. And so the legislature said we want the courts to stay out of this. So the immunity, so getting down to the specific employee, what I've been talking about the immunities before, it's pretty much for the political subdivision. So that township, that ambulance district, that village or city are going to be immune. Again, if it was discretionary, if it was a governmental function. The critical issue here is when is the individual employee immune? And there you have immunity as a EMT paramedic for the political subdivision, unless your acts or omissions were outside the scope of your employment. So you are doing something on your own time, you were not working at the time, or you do something that has nothing to do with your employment. An example of that that I always think about was there was a police officer, again in the city of Youngstown years ago, that left his shift and went over and beat up his sister. And she ended up suing him, and the city said that really wasn't part of his job functions. And that was one of the defenses, saying we're not responsible for our employee, and particularly providing a defense for him. And we'll talk about that. And again, the second is if the acts or omissions were with malicious purpose, in bad faith, or wanton or reckless manner. Malicious means you are acting with malice. You're intentionally trying to hurt somebody. That's the brother going to beat up his sister. In bad faith connotates a conscious disregard for the rights of other people. So again, that's really making that intentional decision to do something badly. And those typically aren't the ones that we have to worry about. I mean, obviously, if you're doing something with a bad purpose, with malice, it's likely you're not going to have immunity, but you've placed yourself in that position. What you have to understand here is that if you act wantonly or recklessly, and again, wantonly is worse than reckless. Reckless is just that, driving that 50 mile an hour down the road. And if the court determines that your conduct in driving, and again, that's the most likely area where you're going to get in trouble, was reckless, you are not going to have immunity at that point. And then the last is where it's civil liability is expressly imposed on the employee. And the court points out, or a statute points out, however, that the word shall, or even a statutory duty that you have to do that, or a criminal penalty does not necessarily equate in civil liability. The statute has to say that the employee would have liability. So I mentioned when you're immune. So if you get sued as a employee of the government, there are two things that this political subdivision toward immunity section or statute talks about, is providing a defense and providing indemnity. Now, in the defenses, they're just going to have to provide a lawyer for you and defend you throughout the case. If there's a judgment rendered against you, the question is, do you have to pay the judgment, or does the political subdivision have to pay the judgment? And that's called indemnifying you or indemnifying the employee. So the first thing the statute looks at is when does this government have to defend the employee? Well, when the employee wasn't acting in good faith, we already talked about that. When you're acting outside the scope of your employment. So again, you do something on your own time and they sue you and the government because you're an employee of Poland, Ohio. If you weren't in Poland, you weren't working for Poland Fire, you were someplace else, Poland Fire is not going to defend you. And then the last is the employer is the plaintiff. So Poland is suing one of its employees. We don't have to provide a defense. Poland doesn't have to provide a defense to the employee either. So that's not likely going to be the case. Typically, it's going to be where you weren't acting in good faith or you weren't inside the scope of your employment. Now, the second part is talked about is indemnifying. When do they have to indemnify you? Well, again, they don't have to indemnify you for punitive damages, and they don't have to act if you were acting in bad faith or when you're outside the scope of your employment. So the standards are a little different, but typically, unless you were doing something intentionally very badly or acting, again, like in bad faith, they're going to have to provide a lawyer for you, and they're going to have to indemnify you. Or like I said, in the government, and you may have immunity anyway. So in most cases, if you look at if it boiled all this down, that for the most part, you are going to have immunity unless you were driving recklessly. You're going to have the political subdivision, I'm sorry, is going to have immunity unless you were driving recklessly. You're going to have immunity unless something, or I keep saying the political subdivision is going to have immunity unless it was something on the grounds. It's a violation of a federal law. And at the end of the day, unless you were acting in bad faith, unless you did something intentionally that rises up to that highest level of harm, you're going to have immunity, and they're going to have to pay for any damages, even if there wasn't immunity there. For most of what you do. Now, there's a little distinction, and we're going to talk about that next, dealing with the EMS immunity. So EMS immunity is found in chapter 4765, and 4765 is EMS in Ohio. All the issues relating to EMS care, your certification, renewals, CE, everything can be found under this chapter. And 4765.49 deals with EMS immunity. So there are subsections of this that we'll talk about, but the first one is EMS providers. That's you. You have immunity for your acts or missions within the performance of your duties, unless the act or mission was willful or wanton. So remember that under governmental immunity, you had immunity unless it was in bad faith or basically intentional and outside the scope of your duties. Here, you have immunity unless it's simply willful or wanton. And it doesn't say reckless, right? So now we're getting closer at 100 miles an hour on the roadway for you to not have immunity. Public provider immunity, it's the I said public provider. Public provider. The government is immune unless your acts were willful or wanton. Again, the term reckless isn't used there. So it's so if you're liable under Section A, if you don't have immunity, neither does your employer under Section B. Student immunity is the same thing. It's basically students who are out, as part of their education, are claimed to have done something wrong. They also have immunity unless willful or wanton. Private providers have immunity for MVAs. Remember, we talked about the government and having, if you're running to a call, there's immunity unless, again, willful, wanton, reckless. We talked about those terms. So this is the section that actually provides immunity to the private EMS provider who's driving. But you'll see there, unlike the governmental entity, the private provider, for you to have immunity, you have to have a CDL. And your behavior can't be willful or wanton, and it must comply, again, that section with 451103, which is that stop sign. So if you go through an intersection without stopping, or through a red light without stopping, you're not going to have immunity. But I find it interesting that to provide immunity to private provider, here you have to have a CDL. And again, that's not in the section for the public provider. Again, we talked about that. There's also, under that same section, dispatch immunity. There's immunity for EMS coming in from across the border. There's teaching or education immunity, accreditation immunity, and quality assurance immunity. So those are just other areas, areas of service related to EMS provision that there are immunities, and basically all of them are, unless it's willful or wanton. This is a case that made it a little bit more difficult and didn't help the government out, because as I went through and said, well, you have the government is immune for governmental functions, and governmental functions are talks about EMS, police, law enforcement, fire. And there was a case involving a governmental entity that the charge was that the EMT or paramedic provided had immunity, that he had done something wrong, and the government said, hey, you have immunity. And the plaintiff, the injured party, said, yeah, well, the government immunity says that he has immunity for EMS, but we have this EMS immunity statute, which is much more narrow and talks about immunity unless it's, willful or wanton, as opposed to, straight blanket governmental immunity. And this Riffle versus Physician and Surgeons, the Ohio Supreme Court said that the EMS statute is more specific and more narrow than the broad general governmental immunity statute. And because this whole section deals strictly with EMS immunity, we're going to go, when it comes to whether the EMS immunity of the governmental political subdivision immunity rules or the EMS immunity is the one that rules. The court said we go with a more narrow one, more specific one. And so if it comes to the provision of EMS services in Ohio, the EMS immunity section is the one that applies. So unfortunately, if you'll remember, under the governmental immunity for you, it was much more broad, and it talked about outside the scope of your employment, et cetera. And now they've narrowed it. So getting back to your your individual immunity for the provision of EMS. I'm just going to go back a second. It's so if you were actually performing EMS in the old days and you were a governmental entity, you had immunity because there was EMS had was completely immune as a governmental function. But now EMS individually, you don't have immunity when your allegations are willful or wanton, which again is greater than reckless, it's greater than negligent. So, and again, the employer will have immunity as long as you weren't willful or wanton. So again, we have to worry about your driving if you're reckless, and we have to worry about your EMS provision if it's willful or wanton, and those are going to apply to both the private providers and the public providers. It's pretty much now the same standard under 4765. Just real quick on governmental or Good Samaritan immunity. This really applies to you individually when you're not working. It's when it's outside of a medical, it's when your act or omission, something you do is outside of a medical facility. And again, it's unless it's willful or wanton. And it says, and remuneration is expected. So, you know, if you're outside facility, but you're running for private EMS where there's expectation that you're going to charge for that call, or your service is going to charge for that call. There's not Good Samaritan immunity. If you're walking down the street and somebody has a heart attack and you go treat them, you're just helping out, then the immunity would apply. If you're a paid firefighter or law enforcement officer, that being paid for your services, your shift work does not count as remuneration. It specifically does not include, like, paid shift EMT or paramedic. So this law makes a distinction between shift law enforcement and firefighters as opposed to EMS personnel. I don't know what they would do if, again, you're a firefighter paramedic and, your duties specifically include EMS. I would think that it says firefighter. I would certainly make the argument that if you're a paid firefighter, this section could also apply if you're out running. Other immunities, just informational for you. There is quality assurance, disaster care, AED use, and then people involved with school athletic programs, trainers, and to the extent you're helping out, providing EMS or services for games, or as part of that school athletic program, you could probably sort another immunity under this section. Just a couple of cases that are out there, and the first one is the Blair case, and this is a 2011 case, and I could have talked about it a little earlier. This was a claim against a couple paramedics where the patient died, and the court in 2011 said, hey, these are paramedics, you're claiming they're from the government and they were providing EMS services, they're completely immune, and threw the case out. And then in 2013, that Riffle case came along and basically changed the entire analysis. So before 2013, if you were a governmental medic, you were in pretty good shape. Now the court said, well, as long as they're alleging in the complaint that it was wanton or willful or wanton, we're going to let the case continue. That may still get thrown out once the court looks at the facts, but it's not going to survive a immediate motion to dismiss. The Bush case, again, is from here, from our local area. It's long enough ago. It was 2008, so I don't know how many of you remember it. But basically, in that case, the medics went to the patient's home. Patient weighed approximately 350 pounds, had passed out on the floor from a syncopal episode. Upon arrival, the first squad phoned in for assistance for a lift assist. After lift assist was placed, the patient regained consciousness and complained of pain. They provided EMS, the crew provided EMS services. Second squad then arrived on the scene. At that time, the provider had a written protocol recommending that bariatric equipment be used to transport patients over 300 pounds. There was no bariatric equipment available. The medic said that four medics placed the patient onto a standard backboard and lifted her onto a wheelchair cot. The patient was strapped to a cot, And there's some difference in testimony regarding the number of straps and whether they were securely buckled or not. The patient claimed that the 2 of the straps came undone. She was then carried out of a house on the cot by the medics. And again, the testimony differed. The patient claimed that only 2 medics carried her out, 1 male, 1 female, and claimed that in the court, when looking at whether they were going to dismiss the case, assumed that she was telling the truth, that there was only 2 people as opposed to 4. They had to carry the patient down 5 to 7 steps to ground level. A bystander who was there testified that he warned the 2 medics that they would be able to carry her on the cot down the stairs. The bystander said he offered his assistance, but it was denied. As the 2 went down the steps, the cot veered to the right. Now, again, there's 2 versions of events here. One from the medics is that they had some difficulty getting down the steps, and they slowly and gently lowered the cot to the ground, at which point the patient sustained some injuries. The other version is the cot tipped and that the patient crashed to the ground and was injured in the fall. And the court, in deciding whether we're going to throw the case out or not, has to take the patient or plaintiff's version of the facts as true for purposes of a dismissal, a motion to dismiss. And the court looked at that and basically said that even though they didn't have the equipment, their actions were willful, as they didn't intentionally disregard a clear duty. They did deliberately fail to discharge any duty or perform a wrongful act with the knowledge and likelihood of the resulting injury. There's no evidence that they failed to exercise care with their complete indifference to the consequences. So it's basically, even if they didn't follow exact rules, it wasn't to that reckless, willful, wanton conduct. It was basically, the court said under most circumstances it was ordinary negligence. Another case out of Scioto County dealt with the patients or the paramedics' actions with respect to transporting a newborn patient. And there was a number of unfortunate delays. There was some difference in the standard of treatment to the newborn, whether they took whether they should have or not should have intubated. There was a couple expert witnesses. One was another paramedic. There was another doctor who testified on behalf of the family and said that that the conduct was reckless, willful, and wanton. And the court in that case said, we've reviewed all the facts, and we don't think that this conduct rises to that level. It was unfortunate, but was really negligent. These folks didn't do anything that was that bad that we're going to hold them liable. And I think one of the interesting things in holdings of this case is, just because somebody else says that this is wanton or reckless or doesn't mean that the court has to listen to them or even agree with it, that we can look at the facts and as a court decide as a matter of law that we're going to dismiss the case because we just don't think that the conduct rises to that level. And in that case, that's what the court did. The court dismissed the charges. But there was another case, the last case that I cited, the Wolcott case, which is out of Cuyahoga County. Cuyahoga County tends to be a little bit more liberal than other counties in the state. By liberal, I mean plaintiff oriented. And in that case, it was a 911 dispatcher. And if you remember, I said that there is immunity for dispatching. But they said that the dispatcher time, it took 4 minutes to check her email regarding protocol changes for dispatch and EMS. She didn't follow long-standing protocol. It required immediate dispatch to a first responder. She provided the trainee with a wrong telephone number for mutual aid. She stopped the trainee as he attempted to look up the number for requesting an ambulance from a city, and she failed to verify the appropriate responder was called. And then she admitted she knew that serious injury or death could result from the failure to follow the established procedures and protocols. So based upon her admissions and just basically the sheer number of mistakes that she made, the court said that we were not going to dismiss the case based upon her recklessness. Again, more than just an ordinary, mistake that I think was because of the sheer volume of mistakes. And so they let that case proceed forward for ultimately a jury determination. So, I think that one of the things that you can look at is, courts can decide the issue of your immunity as a matter of law. And often they do. There are some cases when they let that case go to a jury, and that may be that 50, 60, 70 mile an hour decision. If it's, way out there, you're driving 100 miles an hour, it's no doubt they're going to let that go to a jury. But if you're trying your best and you're trying to provide care and you're generally following the guidelines and procedures that you have, the courts are going to find that you're immune for your EMS, because again, it's not a negligence standard. With doctors, there tends to be, it's a negligence. Was that doctor negligent? For EMS, pre-hospital providers, you have a higher standard that a plaintiff is going to have to prove for you to be held liable, both under a governmental standard and again that EMS standard under 4765. So for you to be held liable, again, we have the driving immunities. We have the federal guidelines, which really don't apply to you. Police officers usually, but not to you. Issues on the grounds of the station, and last but not least, something that you really do that's just stupid and beyond the ordinary negligence of provision of EMS care, and those are circumstances which you have to worry about. So people are always telling you, oh, you have to worry about this, or you do this, you can be found negligent. The issue is that you really don't. Unless you're just refusing to provide care, or you do something that's really out there, you're going to have immunity. And then the other thing is, I didn't really talk about, but I did in the proximate causation. If your patient is really bad off, I'm not sure how they always prove that your acts or omissions cause that patient any more harm. You'd have to almost prove that the patient would have survived had you done something else. And it's the death cases from a plaintiff's lawyer standpoint. It's the death cases that they want to pursue, because those are where the money is. If you didn't do something, a person got an infected finger, which went away in a week because you didn't treat something. Okay, fine. Maybe you were wrong, but that from a practical standpoint, there's really no medical expenses. There's no loss of life. There's no lost earnings. And a lawyer's not going to be willing to take that case to court because there's no money in for them. So the cases that the lawyers are interested in, family interested in pursuing, are typically the death cases or something that's that's very serious, and they're going to have to prove again two things: the willful wanton as well as the proximate causation. And again, if it's a bad case for a pre-hospital patient, that's pretty hard to do. It's most likely going to occur where you did not properly diagnose or recognize a condition, and so there was no treatment rendered at all. And ones that you might see in the hospital, I've seen the pulmonary embolus where hey, that should have been diagnosed and the person wasn't treated, ends up dying, or like subdural hematoma, some other condition that may be hidden that you should have recognized, and there wasn't a lack of treatment. Again, if you get that patient to the hospital soon enough, and there's not a delay, you kind of, okay, maybe I should have, but now it's in the hospital, it's really the hospital's position, and the idea is that medical provider in the hospital should recognize it. So a lot of times, again, pre-hospital, you may be able to push off any fault to the hospital. It becomes a causation issue again. Who should have recognized that part? And if the hospital recognized it, then they should have been able to do something. So I wasn't the real cause of that patient's demise. Consent refusal of care. Basically, we've all been told that every individual has a right to refuse care and treatment. A little difference between legal capacity and mental capacity. Legal capacity, we always talk about dealing with kids. A person who is a ward of a guardian because they aren't able to care for themselves, and they could be of any age, but there's a established guardianship. And then I put prisoner question mark, because the interesting thing is, from a governmental entity standpoint, I talked about duty. Police officers do not have a duty to provide care. It's often said the government does not have a constitutional duty, I should say, to provide care. But under the 8th Amendment, if a person's a prisoner and can't care for themselves, under the 8th Amendment, the government does have an obligation to at least try to provide care to that prisoner. They can't just let, the prisoner's having a heart attack saying, sorry, you're in the back of the cruiser, we're not doing anything. That's why you'll see police officers, when you have a person in custody, making sure that person's checked out, because they have a constitutional obligation under the 8th Amendment to provide care to that patient. But just the same, that patient, if they have the mental capacity to do so, they can say, I'm not gonna undergo that treatment, as long as they understand what they're doing. And that's basically then that they have a quasi legal capacity to make some decisions. At the end of the day, the issue is, do they have also does everybody who has a legal capacity to make a decision have the mental capacity to do so? And that's where sometimes out in the field it gets really hard for us to decide, does that person have the ability to understand or comprehend what we're talking about? And again, I think Renee's going to get into more of this later on, but the basic things is this person competent? Do they understand the risk and consequences of the refusal of the treatment? Do they accept those risks and consequences? And then the person refuses care and treatment. And I think Renee will talk a little bit more about those documenting those factors. Again, we run into the incompetent patients with mental illness, impairment, or some sort of medical condition, which include head injury. And we're out in the field and somebody who is suspected to be under the influence of alcohol or have a head injury says, I'm not going to have treatment. That's where we really get stuck and try to decide, what's the proper course of action. Because if we leave that person here and they in fact do have a head injury or medical condition, or they've got some other issue and something happens to them, we know there's going to be that lawsuit against us for not treating the patient. The problem always becomes, okay, fine, and we think they have a head injury, or they're impaired, and that we think that they really need to go to hospital. If they refuse, what do we do at that point? That's where things really gets difficult. And so often we'll try to have the law enforcement help us out. And that when we're dealing with section 5122.10 of the revised code, this is basically our pink slipping section. We're dealing with people, it's not so much in these cases of risk of physical harm to others, it's really to themselves if they're allowed to remain at large. Although the second part of that statute talks about the person's mentally ill subject to court order, and that's where I think it's really tough, because that section talks about mental illness, but what happens if they have that medical condition or they're under the influence of alcohol? Now, the police officer may be able to arrest that person and say, I'm going to get a medical treatment. But again, these are things that we're working out in the field, and people aren't typically pulling up revised code sections trying to get against the law enforcement officer. How do we get them to the hospital? And I think a lot of times it comes down to our relationships and our ability, to the extent the person's conscious, that we're going to convince them that they need to go to a hospital and need to seek treatment, and we're going to have the officer basically say, hey, you're doing this, or I'm going to take you because you're going to be under arrest, or you got some other issue going on. Of course, if they're unconscious, it makes it real easy for us, and we don't have to worry. But we always get into that implied consent that they have the right to that we have the right to transport a patient, because they've given us their implied consent that they want treatment. One of the issues, when we deal with mental health patients, is who has the right to pink slip that patient. And this is the list under that statute that talks about that. And it's always driven me crazy that we have basically law enforcement officers that have that ability, but I don't know what I've never gone through it, so I don't know what type of training they have in determining whether somebody is subject, has a mental illness. We expressly have, dealing with people with mental health issues as part of the EMS training, and we're talking about how we treat them and how we're going to transport the patients, and those are in our orders, but we're not given the ability to order them to be transported to the hospital, even to make that determination that they need to go. And a lot of times the law enforcement has us come out and say, hey, we want to have this patient assessed. Well, that's fine, I'll do the assessment, but at the end of the day, you're the one who has to make this call whether they qualify for transportation. And I mentioned before about jails, again, anybody who has custody of a prisoner, somebody who's incarcerated has the ability to make that determination as well. Whichever, if it's a law enforcement officer and they're going to make that decision, they have to complete a written statement. And it, again, has to include the circumstances under which the person was taken under custody and state the reasons why they believe that a person's mentally ill. I mean, they may be parroting what you advise them, and again, why that person represents a substantial risk of harm to the person if left at large, basically. Again, that form must be completely filled out. Has to include the facility where the patient's being transported, has to be date and time approved, and again, they have to include a statement of belief. The statement must be made available to the person upon request. Again, depending on the status of your patient, that may be a little difficult if they request, although I'm not sure they would. And again, you have to explain to the person signing that, meaning the law enforcement officer, has to tell them who they are, what their designation is, that they have to advise that they're not under arrest and they're being taken for an examination at the facility, and have to tell them exactly where they're going. That officer must make every reasonable and appropriate effort to take the person into custody in the least conspicuous manner. To the extent EMS is involved, I mean, that burden is not on us, it's on the officer. But we're part of that, and we try to treat the patients with dignity. And again, you'll see that's imposed at least on the law enforcement officer. And the officer has an obligation to preserve the safeguard the personal property and possession of or the premises occupied by the person. That certainly that last one makes sense as to why that obligation would be imposed on the law enforcement officer as opposed to EMS. In terms of maintaining that property, I'm sure they want the law enforcement officers used to taking into custody and inventorying property. That's a good job for them. But I think our role here is very limited, and often, we get into, fine, you signed a pink slip. We don't look through it. We assume that they've filled it out properly and they've done everything they need to do. And then we're asked to transport the patients to the hospital, and the law enforcement officer doesn't want to accompany us, which is, difficult, because we run into, well, what is the condition of this patient? And I know of at least one community and one provider where they've said, we're not going to transport this patient unless a law enforcement officer accompanies us. Then the police department saying, we don't have the staff or personnel to be transporting that patient to a hospital. EMS provider says, that's fine. Well, they're your problem. You're the one who has the responsibility of them. And we're just telling you, we're not transporting that patient without you in the back. So you figure it out. You can take them in your cruiser then. And so it's just really difficult, depending on what your policies and procedures are, because it is the responsibility of the law enforcement officer to get that patient admitted and to make sure that, they're following the code. But from a practical standpoint, is it realistic for the officer to transport that patient in the back of a cruiser? And I think there's got to be some working relationships between law enforcement and EMS to try to address these issues, and it's probably on a case-by-case basis. Ultimately, we may be required to restrain patients and otherwise secure them. Securing patients, one thing I want to note is that from a liability standpoint, I mentioned that situation where the patient claimed that she was injured as a result of being dropped. I have seen a number of those scenarios. My law firm defends both UH and Cleveland Clinic and others, but we also represent a number of public and private providers. And we've had at least 2 incidents where patients were cots tipped and patients fell. One where the patient who fell off the cot died. Now there were some, again, issues about proximate causation, but the transport of patients is another area that we don't think about, where patients could be injured. In that case, a wheel of a cot got stuck in a defect in the sidewalk. So people, especially it's a night where we go places we're not paying attention, or we're transporting a patient across grounds. You have to be careful that that there might not be an incident or to prevent an incident from occurring, keep in mind that I'm not so sure that just because a cot tips over that rises to a level of, willful and wanton. But again, it's something we should be aware of. The restraining patients typically, now you're making a conscious decision. This isn't where you forgot to do something. You are restraining the patient. But we operate under protocols that specifically address restraining patients. And so while there may be claims made, as long as you are making every effort to follow whether it's chemical restraint or physical restraint, you're following your protocol. If necessary, you're getting direction from a physician. I don't see there being a problem with any lawsuits. I mean, I'm not saying you can get sued for anything, but from a liability standpoint, as long as you're watching the protocols and following them, I think you're going to be in really good shape. Advanced directives come up. We have statutes on DNRs in Ohio, and if we're looking to see what that DNR, do you have a DNR? Is it here? You're looking over it, you follow it. I think things, for the most part, if you're following the DNR, it gets back, there's immunity, so there's not really an issue. I've been presented in the home with durable power of attorney for healthcare, durable power, or just durable power of attorney at all, or a living will. Never had anybody shove a will in my face, but I have had the living wills and durable power of attorney for healthcare, and even once a durable power of attorney, and they don't have any effect for you in the pre-hospital EMS environment. Durable power of attorney and the living will can have meaning in a hospital, but there are conditions that have to be met for those to become effective. For example, for a living will to become to be used, there have to be two physicians who are going to test that the patient meets one of two conditions, which is a permanent unconscious state, i.e. a vegetable, or terminally ill with no hope of, short-term no hope of recovery. So unless you're shown a DNR, I wouldn't follow through with it. I wouldn't listen to the family at all. Ultimately, if you're in a situation, where there is a question like we use all the time, do you have to terminate care? We call medical control and get approval there. It's not a decision we would necessarily make on our own. So that takes off, that relieves you of any liability at that point. So HIPAA, there's entire lectures that are done on HIPAA. The guys, Doug Worth or Doug Wolfberg and Steve Worth do some great presentations on HIPAA. We could be here all day. The thing that drives me crazy about HIPAA is in the EMS pre-hospital environment, is everybody throws out HIPAA as a basis why you can't do anything. And HIPAA is really narrow in its scope, and that is it's private medical information used for the care, diagnosis, treatment of the patient by a covered entity. And so if you have providers that aren't in the Medicaid, Medicare world, if they're not medical providers that are subject to that statute, it doesn't apply. And HIPAA doesn't apply. I run into situations where people are having some tests for purposes of employment. No, this isn't for purposes of medical treatment or diagnosis. It's for purposes of employment. So again, HIPAA doesn't apply. So I think if you are dealing strictly with patient information, that again relates to that patient's care, diagnosis, and treatment, chances are it may fall, it will be covered by HIPAA. But if it's in some other environment, it won't. Now, what does come up a lot is does HIPAA apply to run sheets? We fill out in Ohio, if you're a governmental entity, we fill out the OFERS reports, Ohio Fire Incident Reporting System, and we're putting in what's the why are we going there? What's the code? And we have some medical information that may be in that section. Typically, that is not going to be HIPAA protected. It's just basically ordinary run sheet. So that was likely not protected. The run sheet itself may be. In Ohio, we have a couple of attorney general opinions, and what they basically say is you have to look at the individual run sheet to determine, what may be protected, why not. Often, what the attorney general says, we have to redact the portions of the sheet. We may or may not have to redact the patient's name. The address may be a non-protected information. For example, a federal classified drugs, class 1, 2, whatever, they may say that under federal law, the entire sheet itself is protected. So Attorney General said you have to look at that sheet and go through it and see what kind of information's on it. Was it used in course of diagnosis or treatment, or is it just a public record that is required to be released? I will say typically, to err on the side of the conservative side, what I tell my clients is, don't release it without a court order or a signed authorization form. If you don't have those, just refuse to release it. And most people don't pay attention to the Attorney General to say that, oh, I got to go through this and just redact the sheet rather than withhold it completely. Dispatch recordings that where a person may give information over the phone, is what is going on with the patient. That is not protected information. They've said that information is not given in anticipation of care, diagnosis, or treatments given to get EMS there. And it's basically when they talk over the phone, they don't have that expectation of privacy. Photographs are typically not protected either. It's not a communication. You may take a photograph for helping a doctor. Here's the severity of the car crash, but things taken on scene are likely not are going to be public records if taken by a governmental entity. I advocate, and we'll talk a little bit later about some digital imagery policies. Mandatory reporting, just a reminder to everybody, child abuse, you have an obligation to report, as you do, if you have suspected neglect of individuals with disabilities. Elder abuse, the conditions there, 60 years of age or older, if they're handicapped, can't provide for their own care, and reside in an independent living. It doesn't talk about nursing homes, it talks about independent living, but I think even if I saw it in a nursing home, I would at least try to follow up with that. I will tell you that our firm represents a lot of nursing homes, and we have had EMTs and medics provide abuse reports to proper authorities. We get calls. I've had some calls recently with administrators who lament about that because they said, we could have explained where that sore was from or whatever. We have the documentation. I wish that paramedic or EMT had just come to us and we would have sat down and at least they would have had more information to make a decision before they reported it. I have mixed feelings about that. I think it's, from you, it's on a case by case basis. You may, if you think it's from, it's not from the administrator, maybe it does help to have the administrator know about it. They're certainly going to want to take action. But that's on a case by case basis. But you can ask, hey, where do these sores come from? Or why is this condition like it is? Victims of crime, gunshots, fire. Typically, again, you're going to take these folks to the ER, so you can make sure, hey, this is going to get reported. Domestic violence, where there's the threat of threat of loss of life. So that's basically a felony level offense. Something minor you don't have an obligation to report, but again, you want to pass that on to hospital personnel. And again, that should be in writing in your reports. Human trafficking is there's now in many of the protocols around the state, they address trying to deal with patients who are victims of suspected human trafficking and to work with them in law enforcement, but I've not seen it per se in the revised code that make it mandatory on you to report. Patient abandonment, I know it's one of the areas that I was asked to discuss, and my issue on patient abandonment is that it's really it's something we talk a lot about, but we don't often see because it's, you go, everybody has the idea, hey, I'm here, I'm going to get a refusal. The person understands all the risks, they understand what they want to do, so we leave them at that point after we get the refusal. If you're in a situation where you always, okay, who am I handing off as patient? Am I a paramedic, and for whatever reason I have to give this patient to an EMT? Is that abandonment? Theoretically, we may run into a number of cases that are abandonment, but I always think that from a practical standpoint, being in the field, can you justify why you may have to abandon that patient? And if so, what are the potential damages or risk of doing so? And I always think about the situation where you're out as an EMT or paramedic and you're at an auto accident scene, there's no damages to the car, it was a minor fender bender, police called you out, or you got the dispatcher on scene, and you're in the process of just checking that patient. Yeah, I'm fine. I don't want to go to hospital. Okay, we'll get that refusal. And a cardiac arrest comes in for, half a block down. Just stick and keep filling out the refusal and call the second second crew to go to the cardiac arrest, or do you leave the patient there, and say, sign here, or, hey, we're just going to document and we leave. Technically, if you haven't got all the information of that patient, I suppose you abandoned the patient. But in the general scheme of things, is there really a risk by leaving that patient? Hey, give me your information. We'll follow up later. We'll check on you. We'll call you. We'll document it. But this patient, based upon the totality of the circumstances, doesn't need our care. And we're doing this triage where, again, we may have to leave, but we've got this patient over here that's critical, and it's really going to do a lot more good. And I always think, how does it play out to a jury? This guy comes back and says, well, they should have, they should have stayed with me and filled out the forms and left that the cardiac arrest patient, to go, and they had somebody else respond. I don't think that buys well to anybody, even with the EMS board. Somebody wants to file charges, they abandon me. Well, I was going to help the patient just down the road who was, had a cardiac arrest. I just don't see, from a practical standpoint, anybody getting worked up about that. And I think that most of us who are faced with some critical condition are not going to leave the patient. We're usually put in a position, even where you say, oh, the paramedic transferring the patient to the EMT to keep the paramedic in service. Well, yeah, it's to a lower level of care. Technically, yes, that's right. But if we're keeping the medic in service, or the medic has to go to another call, that's a medic level call, an EMT is going to take care of the sprained foot. Yeah, should that medic technically stay with that patient? Maybe. But again, the EMT, it was appropriate level of treatment, and the medic is triaging, going to another call that can make a difference. And I think that's where we have to focus on, what we're really doing out in the field. And, from the proximate cost standpoint, negligence, is it really, theoretically, it's abandonment, but I just don't see it rising to level of either civil liability or, some sort of administrative problem. Ambulance staffing, the one thing I've talked to some people, some folks in the conversations the last couple of weeks were aware of a change, others not. So I just threw this in that, there's always, how many people required on an ambulance, and for a career department or staff department, that the standard has not changed. But if you are predominantly volunteer, meaning non-staffed, non-shift provider, that you do not have to have 2 EMTs, to transport. You don't have to, right now, to transport a patient. You have to have an EMT in the back, but as far as your driver goes, you're permitted to have first responder, a police officer, a firefighter, even just somebody who has EVOC. The idea with the staffing shortages, with the issues they had with COVID and other problems, the legislature basically said, as long as you get that patient to the hospital with somebody who has some training to drive, that's okay. So there was some departments were looking at staffing and issues and how they were going to get patients to the hospital, and that was a different outlook for them. Vests and guns. This is always, we don't have as much interaction here as we normally would, and this is a great topic, but I had some debate a couple weeks ago with people in a fire station, because there are departments around who encourage their firefighters to bring guns with them, or their EMS personnel to have weapons for their own self-defense, particularly in some rural communities where there's a lack of a timely response of law enforcement. The other is providing vests to your personnel. The question I always ask on the vest issue is when you wear it. And most departments I talk to say, well, we have a policy that says that you're going to wear a vest when you go to certain types of incidents. We're going to go to domestic, we're going to go to assault, and we're going to go to potential shooting, and we wear a vest. The problem with that is anybody who has been shot in the EMS community or fire community typically weren't expecting to be shot. Particularly if they had a vest, if they knew that, they either wouldn't have been in the situation to begin with, or they would have been wearing their vest. And so what we have to recognize is that If you believe that the risk of being shot is significant enough to have a vest, then you probably should be wearing the vest all the time. The issue there is that if you're going to wear a vest, it should be properly fitted to you, and most departments don't want to pay that money. If it's that high a criteria, then they should have vests that aren't out of date and really old, and we're going to just pass one around. And so that's I think that we have this idea that a vest will help, but then we do the idea half-assed. So I think that's a critical issue that departments have to address. How critical is it that we have a vest? And if it's that critical, why aren't we doing it right? As to a gun issue, the problem with carrying guns in the fire service world, EMS world, is that people think that doing the concealed carry permit is all that you need, and we don't provide any other options. Law enforcement officers are taught continuum of force. They're taught hand to hand and takedown measures. Then they may be given a baton, some mace, a taser, and then last but not least, a gun. And in the fire service, we think of just carrying that gun is fine. Well, people get put in situations where they don't have those other options. So it's either shoot or no shoot. We don't give them anything else. And in this day and age, with all the things going on in law enforcement with shootings, where we see officers who have those options shooting, I think it's a real risk for firefighters to be put in that position. The next thing is law enforcement have to qualify on a regular basis with their weapons. And if a department is going to do that, they should have those same type of standards, and people should go through, use of deadly force training as well. I mean, the same level as police officers. And then the last risk that you run with carrying weapons is that when an officer goes into a scene, he's taught to watch the scene, put himself in a position that he can protect himself, and that he can maintain control of the weapon at all times. And if you're there and you're providing EMS care, and if you're providing EMS care, your focus may be off your weapon, or you may not be in a position to control it. If you have somebody who's in with you, their job is to watch your EMS personnel, to watch everybody else, and that's simply that person's role, it makes a little bit more sense. But even then, you have to be concerned about, okay, am I going to have this weapon in a position where my other crew members may be in a crossfire, or I may not be in a position to protect them, or again, things could go south. Protecting those weapons, you can't take them into government buildings, including post offices, so that's a problem. How you secure them in vehicles, depending on where you're going to go, is you have to plan these things out. You have to have a proper training. You have to have the proper policies if you're going to do that. Medical recreational marijuana. Ohio is in the medical world right now, trying to get to recreational marijuana. Colorado was one of the first states to pass a law permitting medical marijuana use. It also has a law that says that you can't prohibit anything, but for employer can't prohibit anything that would be legal when the person's off duty. And so it sounded great. There was a guy who had a had a marijuana test in Colorado. He failed it. They fired him. He said, you're punishing me for legal off-duty conduct. That went up to Colorado Supreme Court, and they said, no, pot is still legal federally. So it's not, the employer still has a right to prohibit that, which they did. Depending on where you are, the answer now is that if you have a medical marijuana card, this differs from recreational use, that if a person's using it for a medical condition, then their use is protected under the ADA, and the employer can't terminate or discipline the employer for that use. That varies state by state as to their interpretation of, or the applicability of the ADA to medical marijuana use. It's not been decided in Ohio. If you're on the east or west coast, they've said it's fine. If you're in the middle of the country or south, they say no, the ADA doesn't apply. So we don't know the answer to that in Ohio. But the problem is, from the employer or your co-employee standpoint, is trying to determine when they're high or not, because again, it can put the patient and the employer at risk if you have an accident. Again, it gets back to that reckless, willful. It's like texting or drunk driving. What happens when you get in an accident and you're drug tested, and you come back for, traces of marijuana, how do you prove that you weren't high at the time of the accident? And so that's going to be an issue that it's not really out there yet, but people have to consider it for purposes of your immunity. Social media and digital imagery policies. If you want to get terminated really quickly, do two things. One is take any accident picture, or worse yet, a picture of a patient, and post it on social media. If you're a governmental employee, the issue is who owns that photograph. You took that in the course and scope of your employment. And so the argument is that that's a public record. Public records include digital images. And so, if you then delete it, are you destroying governmental records? Most entities have public records policies that would include that digital image that you took as part of your duty. So you could face taking pictures, raises about criminal penalties as well as civil issues. So don't take pictures unless it's part of your job, and they have. And in fact, I would say other states have now passed laws that have prohibit picture taking, to actually make it a criminal offense for an EMS or emergency provider to do so. The other is, again, social media policy, death by social media. Just because you work for a government, don't think that you have an absolute constitutional right to post whatever you want about what you're doing at work on social media. Again, I do a whole lecture just on that, and that is another way to be disciplined. And one of the problems is you never know what the reaction is going to be until you post it. So always think twice before you do so. We can get, I think I don't know if we want to take a break here before wind up for Renee's thing. I don't want to get too much into just testifying. I can talk about a few things that we'll talk about day in court, but I kind of ran through a lot of us trying to pack it all into an hour and a half. I'm gonna say, I understand Renee's up at I think 7:30. So
That's correct, but if you go a little bit over, it's fine, Chief.
all right. Well, I was just gonna, I was gonna talk, I threw out a couple of slides in here, and one of the things that you're gonna get called to testify, either a civil or criminal case. Now, criminal case, again, it's stuff that you found, and I'm not talking about for these circumstances where you're testifying, on your own behalf, as much as I am talking about where you're going to be called to testify in some condition that you found, or how you treated the patient, or what, that you're talking about the gunshots and so forth. And, the civil side of things is all about money. The criminal side is, charging somebody with a crime. And there can be some differences. The civil side, there's a lot of discovery. We find out things in advance of the trial, where in a criminal case, it's sort of, everybody shows up at court and you throw the information out there. There are some differences, again, burden of proof in a criminal case is beyond a reasonable doubt. In a civil case, it's more likely than not. It's 51%, who tips the scales. Again, we find out, we tend to take depositions in civil cases, where criminal cases they're not. People show up, they're subpoenaed, and they testify right in the courtroom. In a criminal case, there's 12 jurors. In a civil case, there's 8. In a civil case, 6 of the 8 have to agree. In a criminal case, it's 12. So criminal case, again, all 12 jurors have to agree, and the standard's beyond a reasonable doubt. In a criminal case in Ohio, in a civil case in Ohio, it's 6 of 8. There's the civil procedure, which there tends to be more cases, both from your perspective, as a potential party, or more likely, as a witness. They do depositions in that civil case. There's an answer or complaint and answer, written discovery. They exchange documents of medical records. Then they do the depositions, and then they show up at trial. Sometimes there's mediations in advance of that. The deposition is simply a question and answer period. Again, no surprises. So you show up to a deposition, you're subpoenaed, and there'll be, how many attorneys are? It's going to be at least 2, one for the plaintiff, one for the defendant. There was a recent case I saw, actually my firm's involved, where a city and a private provider were both claimed to have committed some wrongdoings. There's one plaintiff. So in that case, there'll be 3 lawyers there, a court reporter, and the witness. Parties can be there. So if you are specifically named, you have a right to attend the depositions. The purpose of, again, the depositions to find out the facts in advance so there's no surprises at trial. It's also to preserve your testimony. For some reason you're not available for trial, you're sick, you're out of the country, you die. They can read your deposition or play it by video if they've done it that way ahead of time. Also, if somebody changes if you change your testimony, they're going to use that to impeach you. So you need to be prepared so you get it right the first time. And last but not least, I use depositions to size up witnesses. I want to see what they look like, how they present. You can have the same exact facts and two medics who did the exact same things, but one may come across really credible and make a great appearance. The other one, might be just how they present. You all have coworkers that you look at going, I wouldn't trust that person in the world. If they come across that way for a jury, that's important to know in advance. So that's one of the things I like to do that. In the old days, the question about where depositions would be held would be, which attorney's office do you hold them, or do you hold them at the courthouse or some other neutral site? In the last 2 years, big surprise, they're doing a ton of depositions by Zoom. Some lawyers hate them, some don't. To me, it depends on what the case is about. I prefer to do them in person where I can really evaluate the witness, but sometimes it's just hasn't been possible. And there's certain, a lot of courts are starting to develop protocols as to what, who can be in the room with you if you're going to do it by Zoom and what can be on the table and so forth. Again, people who are present are typically attorneys, the witness, any other parties, and a court reporter. One of the things that's critical, no matter what the circumstances, if you're going to testify, make sure you meet with an attorney ahead of time who can try to figure out, even if you're not a party, why are you being called there? What are they going to ask you? I've had friends who've been subpoenaed. I call the lawyer and say, okay, why is my client or my friend being subpoenaed? What are you looking for? What are the issues that are present in the case? What are you expecting to ask? And that's a fair question, even if the prosecutor is calling you. Why am I being called for this run? What are you looking for as part of my testimony? They should explain that to you so you know what to prepare. And if it's a lawyer who's either helping you or the prosecutor, they should say what's the likely test? What is the likely questioning that they're going to use for cross-examination? What are you see as the weak points in my case that I need to prepare for? For an EMS setting, a lot of times it's, do I bring my report or not? In like fire cases, do I bring my investigative file? Or, if we've had something going on, have we conducted an internal investigation and we have our findings? My answer generally is yes, because I want you to be able to refer to your report. I think it's helpful to have that with you. And again, usually the lawyers are going to have it anyway, so you might as well have yours. Two types of testimony. One is fact witness testimony, which is basically what you saw, what you heard, what you did, and the story. An expert witness is an expert's permitted to give opinion testimony. So, based on this, I think this was appropriate, or I believe that this person was under the influence of alcohol or drugs, and the defense lawyer may object to that, but they're going to ask you those questions, and they're going to ask you do you have training in recognizing these things? Do you treat that patient, etc.? And one of the things in the fire world or otherwise, I always ask people, do you think you're an expert? If you're on the stand, so we ask you, do you think you're an expert paramedic, or do you think you're an expert fire investigator? And the lawyers try to make us doubt ourselves and say, oh, well, I'm not really an expert. And, I don't know what I would call myself an expert. That's what they're trying to get you to say in asking that question that way, to make you self-doubt yourself. But an expert is simply, under the rules of evidence, anybody who has specialized knowledge by virtue of their experience, education, training. So, if you think about, you as a paramedic, the average person doesn't know, 10% of what you do. You went to school, same with firefighting and fire investigation. You went to school, you have experience, you have training, you've been out there doing this, you're an expert. So, are you claiming that you're an expert as a paramedic? Yes, I am. I qualify as an expert. If I'm a fire investigator, I've been asked that question. Absolutely, I am. I have specialized knowledge. The jurors here don't. So, and the judge is going to agree with that. It's up to you to sell when you're on the stand. If you're going to be asked opinions, that's one of the critical questions of a lawyer that's subpoenaing you, or, that prosecutor. Am I going to be asked opinion testimony? If that's the case, be prepared to sell yourself. Most of you should, if you've not done so already, I mean, you're going to have a resume, but you absolutely should have a curriculum vitae, a CV that outlines your education, the courses you've taken. If you've taught classes, you should have it all listed. And that should just accumulate over time. Because, I like to have that with me. I'll hand it to the prosecutor. Do you have a copy of your curriculum vitae? Sure. Mark it as an exhibit and see how thick it is. And this outlines your, I've on fire investigation case, I said, I've had whatever it was, 400 hours of fire investigation coursework after my fire 1 and 2, investigation courses. So you want to be able to sell yourself, and the better that you can sell yourself when you testify, the more credibility you're going to have with the jury. Again, basically, prepare for events, understand the issues and disputes. Let's see if I have, go on the next page. You should, I'm going to give you my basic lines for any deposition, and then we'll save for another day. We'll get into some of the trick questions and things that they're going to ask you, but the rules in any deposition are: listen to the question. If you don't understand the question, tell the attorney asking you that you don't understand the question. Make them rephrase it or repeat it so you're comfortable with what it is that they're asking you. If you don't know the answer, tell them you don't know. Don't guess, because if you guess wrong and it comes out later that your answer was incorrect, they won't know whether you're guessing or lying. They'll just know it was wrong. So, and then if you know that, if you understand the question, you know the answer, then keep the answer directly to the point. I've had witnesses where you ask them, what year were you born? They tell you the age, and then what hospital they were born in and what city, and how long they lived in the town during their childhood. Just asked you, what was your date of birth, or how old you are. So the thing is, just ask the questions directly. On cross-examination, particularly, you want to keep it short and to the point. The more you talk, the more ammunition you're giving a lawyer to ask questions, that ask follow-up questions. And if there's a need to rehab your testimony, if you answer a question and you're honest and you as you should be, to answer a question, the lawyer who's on your side will follow up and give you a chance to rehabilitate, an answer that he perceives as weak. And again, if you've done your homework again beforehand, you're going to know how to answer some of those tough questions, or you're going to know this is what I'm going to do to rehabilitate your testimony, because we know he's going to ask you these questions, and here's going to be my follow-up to help you out. I think I'm now just a little past my time again. This is sort of a quick on testifying, but I think we've covered everything that was needed, other than Renee's section on documentation for your EMS law requirements. So if you have particular questions, again, you can always send them to me via email. If you're writing stuff down and didn't see it initially, my email is dcomstock@bsphlaw.com, or ask Larry, one of the folks know, and I will, you can send them questions, they can pass them on to me, and I'll try to get you information. If it's something that the whole class would be interested in knowing the answer, then they can pass them on to everybody or share the info.
Hey, Chief, we do have one question in the
Yep.
in the chat box from Will Ferrando from Boardman Fire. I'm sure you know Will.
If it's from Will, I'm not answering it.
Pleading the fifth.
Will's lucky he got promoted again, because if he hadn't, he'd be another plaintiff in a lawsuit against some building owner here soon. So good move, Will. All right. So questions? You said what's Will got to ask?
Will's question is regarding the photography and everything you were talking about, that there have been recent pushes from municipalities for fire and EMS personnel to begin wearing body cams. What do you think about that? Where would the liability and stuff fall with that?
So there are if you read the policies and the law often on body cameras and they're aimed for police officers. So I will tell you that police officers are often sued by the public, particularly on excessive forces. From the fire and EMS standpoint, we very rarely get sued from the public. We get sued from our fellow employees, or as an employer, you get employee versus employer lawsuits. It's like on a police officer, it's like 80% of their lawsuits are against police department from the public. On the fire, it's like the opposite. 80% of the lawsuits are from internal. So the cameras in the police world are there to protect the police officers. And there's a limit of what can be released. So again, those cameras are public records. They have to record them. One of the biggest issues right now is they have to save those because they're public records, and they have to be kept for a period of time. And so it's not the camera expense is one thing. It's the storage issues that are another. So on the fire side, where it gets more difficult is, again, you think about police officers, they're doing public stops. They're walking into stores. The number of times that they go into homes is less. Think about the number of times we're going into homes for EMS calls as opposed to, traffic stops or some other public event. So I'm not as big a fan for the needs of cameras on police, on EMS personnel. But where I am a proponent of cameras, and Poland's looking at, we're trying to implement this. We've broached this with our board, and are in that process of putting cameras in all our vehicles. Because again, where did I say that one of the greatest risks for EMS or fire personnel is that driving, right? Did we stop at that stop sign or traffic light? How fast were we going? Who ran the red light? I had a case last year where my client was cited, went to court, and they were able to get out of the lawsuit because they had a dash cam and prove that the other driver was the one caused the accident. That driver went to a lawyer, sued my client, never told their lawyer, but hey, I was really at fault because again, my client was cited and the guy saw the police report. When we showed the other lawyer the film, the lawsuit went away. And I mean, that's what it's there for. It's to protect us. And I think that's something that whether it's in, ambulances or fire engines, that should be one of our greatest areas for us to put cameras.
Thanks for that.
Yep.
I think you have one more. Someone's got their hand up, trying to see who. Mike Castle, do you have a question, or is your hand up by accident?
No, I do have a question, David. And unfortunately, I got booted right at I guess the wrong time. What was the significance in your 5-second summary of the significance of that riffle case? I actually was the medic on the private company that transported that patient.
You should know. You should have you give the outcome of the case, and that's always one of the things that's interesting to me is I try to use cases that are pretty old, so I don't run into personnel. But the holding on riffle was that when it came time to which immunity applied, which was governmental immunity versus the EMS immunity. In the governmental sense, that because the EMS immunity was more specific, the EMS immunity controlled over the broad governmental immunity. And unfortunately, that took away the absolute immunity that EMTs and governmental entities enjoyed and made it so you only had immunity if it wasn't wanton or willful. So it went from a absolute immunity for providing EMS to a qualified immunity, meaning you could get around it if the behavior was really bad.
I see, because after my deposition, their counsel came into the hall with us and stated, "Look, you guys did everything right per your protocol. Lack of fetal assessment tools on your unit. You transported, assessed the patient appropriately. We recognized, it's a third trimester bleeding. It's emergent. Ironically, they questioned our mileage, but." We found out my decimal point didn't copy in the lawyer's copies.
Yeah,
so we straightened that out, but it was.
Go ahead.
Go ahead.
No, I was going to say when I was talking about the differences in immunities, and we were talking about the two because I had them. The case where you were talking about not. Are you talking about the Bush case, which was not the bariatric?
No, the riffle versus physicians. Mm-hmm.
Yeah, because that was again, that was the one that they didn't in that case. The only holding that was pertinent for the Supreme Court that I examined was the legal holding of whether or not which standard of immunity applied. I didn't follow up to look and see how the court the trial court looked at it at the end of the day. Because again, if they said, okay, you don't have absolute immunity, what you have is the quasi immunity, the court could then decide whether or not your conduct was willful, wanton, or simply negligent. And if it was simply negligent,
Right.
there was immunity there. I didn't look to see how ultimately the court ruled. I was more concerned with the fact that the standard had changed, and that, so again, for EMS operations became willful or wanton. I had a case that I was
Right.
an expert witness in, where, speaking of driving, it was up in Northwest Ohio, where a firefighter with a 36-hour card and no EVOC training backed a vehicle up and drove over a pedestrian and crushed her skull and killed her. And the court said, and he didn't do a walk around a vehicle, he didn't signal anything for backing up. The woman was wearing earphones and walked kind of behind the vehicle. And the court said it was a tragic accident, but it wasn't willful or wanton. It was negligence. It was an accident. So again, courts will really look to see some sort of egregious behavior before they're gonna say, hey, we're gonna let this go to a jury. Courts are generally willing to say, unless this is egregious, we're throwing the case out.
Right. And that's what I thought it would be on, because we were called for the non-emergent transport before the original responding agency, the city, got on scene. So they were looking at it from the standpoint that they made that decision to transport code 2 before they even assessed the patient.
Yeah. And again, is that negligence, or is that some sort of recklessness? So, or what, willful or wanton, which again is beyond that standard of recklessness. It's that 100-mile-an-hour driving.
Thank you for the explanation of how that impacted.
Yep.
Any other questions or comments out there? All right, well, if you think of any, let us know, or email Chief Comstock, or I'm not sure if he's staying on for the next part or not, but you could email him, contact him. I know for a fact that Chief Comstock is very, very reachable and very responsive. So I thank you so much, Chief Comstock. That was very informative. I like the local flavor of it. That's a big help for us.
No problem. Thanks for inviting me. Appreciate it.
Anytime. All right, with that said, guys, let's take a 5-minute break before Renee gets started, so we can get Renee set up, and we'll go from there. If you'd throw your hands up, we'd appreciate it. All right, everybody, I see Renee's with us and ready to roll. Hi, Renee.
Hi.
Renee is a captain with Vienna Township Fire Department and a paramedic for several years, been a colleague of mine for several years. And she's been heavily involved in QA and stuff like that throughout the years in private and public EMS. And that's why we're asking her to talk about EMS documentation today. We really appreciate her spending her time with us this evening. And if you have any questions, you can either raise your hand or unmute yourself, and the usual process, and ask your question. She's happy to answer. If I guess that's that. It's all yours, Renee.
All right. Well, thank you for having me, Matt and Larry and everybody. Again, I am the EMS coordinator at Vienna Fire. Been a paramedic, EMS instructor, also instructor above all the alphabet courses, AHA and NEMT. So I really like the education side of things. The older I get in my career, which will be over 29 years next week. And through those years, I've done dispatch, billing, EMT, EMTI, medic, management, QA, education. Mainly the times of my career were based on what my kids' ages were and what were the needs of my family, of how I got in those different positions. But overall, QA and documentation kind of seemed to be something most people didn't want to do. But it became my wheelhouse because I do like organization, have a little OCD tendencies, and I really enjoy kind of sorting it all out. I've done a lot of participation on the national level with American Ambulance Association, Ohio Ambulance Association, NEMD nationally. I'm involved in their conferences for years. Have some experience with managed care and negotiating contracts with EMS and ambulance services early in my career, and then reimbursement conferences, which no one wants to go to. That's probably the most boring content for things across the country that I get to see some good places, but the content of the seminars is not great. So a few disclaimers, hi Chief, a few disclaimers before we get started. This information is based on national guidelines. There's trends, there's future projections, the big picture of EMS documentation. I do the disclaimers because sometimes this is a little bit of a triggering subject for people when we talk about maybe changing up some of the ways we think about documentation. These are not policies, laws, or replacements for your agency or your medical direction and what their expectations are for your documentation. So I just want to let that be known from the beginning. This is not a billing class either. However, there are some basic billing principles that I'm going to share that will aid in understanding what's needed in documentation components. So there will be a brief lesson on CMS and some of the things that we need to know about that as you're documenting and how they're affected by that. So I saw this recently, very recently, and it was perfect to add in here today. So being a paramedic, what's the hardest thing about being a paramedic? The paperwork. But like, what's the worst thing you've seen? Really, the paperwork. Nobody likes the paperwork at the end of the shift or at the end of the call. That's the last thing we really want to do. We want to eat, we want to sleep, we want to do other things besides document. But we're trying to make it easier with new technologies and things like that as well. So I love this slide for almost anything that I've taught EMS wise, because professionalism, that's what we're always striving for. We want to be recognized as the profession that we are, more respect for our profession, more pay for our profession and benefits and things like that. But it comes together with, our behaviors, our skills, and our knowledge. And documentation reflects the professionalism, like historically, that's the part of it that lasts forever. So everything we do, every way we progress, we really can sum it up in the way we document as well. EMS documentation, simply defined, it's the process for verifying your actions on an EMS run using written or computer-based records. The purpose of the documentation is fivefold actually. It's providing accurate, comprehensive, permanent records for each patient's condition, the treatment that was rendered, and as well as serving as a data collection tool. Documentation is as important a skill as good clinical care. The old adage, if you didn't document it, it didn't happen, it still holds true. I hear that in every EMT class or medic class, throughout the time that I've been teaching. Somebody always brings that up because it is still true. The evolution of written documentation to EPCRs has really changed the way we document and really improved the way we document in so many ways. So if you see on the left there, the written reports that we used to use, we've been doing this for any length of time. When I would get a attorney request or a subpoena or something for a written record that was in the storage room that nobody ever wanted to go down to, I would be a little bit anxiety ridden because I knew I wasn't sure if I'd find it at all, or if it would be blank, if it would be missing documents, if it would be missing signatures, key information on those paper reports. Sometimes wasn't there. And then we would have, need a hieroglyphics class or handwriting analysis class to figure out exactly who did it or when it was done or where the location was. So glad to see those go by the wayside. I do still see them in a few places in smaller rural areas where they do that as like a handoff to the higher level of care. But for the most part, we've all, converted over to the EPCRs or a patient care report electronically. There's, different products out there. I've used probably 3 of them over my time since they've come out. They all have, pluses and minuses and things that we like about them, things we don't. I think we'll still see those evolve even more over the years. But what they have changed is efficiency. So we can get them done a lot quicker. We can get them done on an iPad, in the truck on the way back from a call for the most part, a big chunk of it. The charts that come from those are more complete because we can actually require information that's needed. So we can make required fields that don't allow, providers to lock it out until we get that, X amount of fields completed. Then we have data protections too. So with all of the security features and things like that of not losing things that we need. And then reporting, it makes a tremendous amount of help on the end of reporting. If you've ever been around long enough to count written run reports on times and number of calls, it's really a pain in the butt. But when we get these that we can just put in a data set that we're looking for and generate a report like response times, scene times, procedure logs, it makes it so convenient to be able to get that information out of there. This is one that will always be dear to my heart. This is a replication of a provider who was very young earlier in my career. He actually left the area not long after that, and he's a chief now elsewhere. And he would still laugh at this, that I'm sharing this. So this is how almost all of his reports are turned in. There was barely any information on them, and he ended this report with no narrative, and it would say TWOI, transported without incident, was his entire narrative all the time. And he would still own this and laugh about it today. And I wanted to send flowers to whoever is going to do his QA when he moved on to another place. But this is what I'm talking about. We went in the basement, in 1999 to the early 2000s before electronics. This is what we would get, just the basic amount of information, and have to send this then to an attorney or a prosecutor or something like that. So I'm glad that we don't have to have this limited information anymore. Excuse me. So why do we, worry about our EMS documentation? There's top 5 reasons. 1, patient care, protocol compliance, the legal or mitigation or risk mitigation, reimbursement, and then data collection. Patient care aspect is, where do we go? When did we go there? Why were we called? Who did we treat? And what did we do? This is the whole picture from time of call until transfer of care on, what happened with that patient that we're going to be documenting. So that's the number 1 priority, of course, is going to be our patient care. Second to that is our protocol compliance. Did we identify the problem with the thorough assessment and the tools we have? And then did we apply the correct protocols for that problem? Legally, do we document the patient's medical legal record thoroughly and clearly? Do we comply with contracts that we might have, local, state, and federal laws? Will this stand up to a jury of 12 of our peers if it has to? And when I say that, it becomes more important. You start looking at your documentation through different eyes and writing them in a different way when you've had to defend one or be in court for one. It's not going to be that piece of paper that's in front of you, the printout. It's going to be on a giant screen for everybody to see. So that's why we talk about some of the things throughout this, keep that in mind. What would it look like on the legal side of things in the courtroom? Reimbursement, it starts in the field. Nobody wants to, really have to be thinking about that, but we provide all the information necessary to submit a complete bill for the service. While there's no guarantee of coverage or payment, do we maximize the chances of getting paid? We want better things at the end of the day. We want to earn more money. We want to have better benefits. We want to have better equipment, better tools, but all of that starts in the field. So if we don't maximize the money that we can collect, then we will struggle later to get those things that we want to improve, our profession. Data collection is becoming more important as we learn, how to use these systems and use the fields that are available to us and get the information that we want. So time and performance measurements are common, response times, intervention times, scene times. Statewide EMS data collection systems, they're evolving too. We're now onto Nemesis 3 for collecting data. There's certain data points out of every chart, starting with the bare minimum. Was it a valid crew? Do we have, an EMT and an paramedic on an ALS unit, and then everything that happened from that point on, collecting times, collecting, information about the patient. And then training and education evolves with this as well. So everything that we collect teaches us what we need to work on in the future. So all of those trainings and the CEs are based on the data that we're getting from the system. If we're doing a good QA program, and really building off of that. The Centers for Medicare and Medicaid Services, CMS. So they define the rules, the regulations for reimbursement at the federal level. What happens after that is all the managed care insurance companies, they follow those guidelines. They don't reinvent the wheel. So everything that they're doing is based on those CMS guidelines. The CMS reimbursement we know is very low, incredibly low. It needs great reform. We could talk about that for hours, and they do at state and federal levels. There's a lot of ideas out there on how we can improve that. Tax base for the entities, whether they're public or private. We run not just on levies, then we would need some sort of incentive or tax feed into the expenses that we have. There's also another thing that's happening more in the West. MCOs like say Cigna or United Healthcare are contracting regionally for ambulance service. So like Trumbull County might go to United Healthcare and say, how many of your insured are in our region? And then they would come up with a dollar amount, much like we used to do with a census in a nursing homes on their bed count. And they would come up with a dollar amount that would be paid to that region and divided amongst the agencies that would transport their patients there. So we're seeing that just very early in the process in the West. And there is some hope that maybe that would help improve our reimbursement, because CMS reimbursement, if you have a heavy Medicare, Medicaid population, you're going to have very low reimbursement rates. They are changing in some ways, paying for refusals. We're including MVCs now, so we can get a good refusal on an MVC and get some payment for that. But at the administrative level, if you have an admin on here, you have to set those charges though. Your township or your village or your city would have to set a charge for the refusal for an MVC, and then you can collect on those. And their thinking on the managed care side of why they agreed to start doing that is they would prefer that the patient refuse at the scene if it's minor injury, go to their doctor, go to an urgent care, than go to a very expensive, emergency room or possibly admission or anything and major testing there. So we are seeing that happen. Community paramedicine is also, kind of on the table there too, looking for payment options for that, on who would pay for it, how we would fund it. And CMS is going to need to probably come into that at some point too. But again, with the insurance companies, it's going to reduce some of the bigger bills, that they control better treating patients in place that are minor medical issues. Medicare and Medicaid audits, they're fairly common. If you've ever been through one, you'll be a lot more aware of the triggers and things like that once you're documenting after an audit. But red flags that may trigger an audit, CMS will compare other providers' records for the same patient from the same day of service. Some people are surprised to know that. So as an example, if you have an ambulance patient that, you document that they were unable to walk and they required the stretcher, but then in the next record at the hospital, the nurse documents the patient as ambulatory, prior to the call at home, and then ambulatory in the hospital to the restroom or whatever. They will look at those things. So those are sometimes triggers to say that the medical necessity was the stretcher, maybe isn't enough anymore. But we should say the truth anyways. We want to be truthful about the patient was ambulatory and assisted to the stretcher. We don't want to say anybody that could walk couldn't. So that's a trigger. And then ALS and BLS ratios are probably the biggest trigger. So a good mix is 70% ALS of your total runs for your service versus 30% BLS mix. Anything higher than that is one of those red flags that they start looking at it. I know personally of an agency in another state that they were shut down and they were at a 90% ALS, 10% BLS. And they actually had used, one of their employees used the whistleblower clause to let Medicare know that they felt like they were being forced into ALSing things that weren't appropriately ALS need. So we should monitor those annually, kind of look at your mix, but 60 to 40, 70 to 30, that's pretty average. We tend to look at, BLS calls a little harder that should have been ALS calls. So we look at those and go, okay, why didn't you do this? It seems like maybe it should have been an ALS call, but we need to look at them in the opposite way too. We need to look at all the ALS calls and make sure that we didn't ALS them for no reason. So if, everything was stable and, the complaints are minimal, do we really need that IV or the monitor to make that an ALS call? I don't think we'll ever question to the point of, the medic has a good documentation of why a call is ALS versus BLS. But if we see that mix kind of, inching its way up over the average, then we take a little closer look at that. So just a few more things just on billing, just to give you kind of an idea where we're going when we start talking about chief complaint and the structure of documentation. We're painting a picture with good documentation. All of the billing goes through coding. We used to use ICD-9 codes for years, and then they upgraded to ICD-10 codes. So just going to give you a brief explanation of that. ICD-9, we had 13,000 codes and colors for everything medical, not just ambulance. Approximately 75 to 150 of those were approved codes used by ambulance billers to paint the picture of that call. The signs and symptoms were linked to Nemesis 2, which we previously used. But if you look at this picture here, this is the Monet, kind of the fuzzy lines, blurry, nothing really defined. That's what ICD-9 was. It was a general code and you matched it up the best you could to that patient. Then when we developed ICD-10, we went from 13,000 codes to 68,000 codes to paint that much more detailed picture. So now we have this crisp photograph, very clean edges, very defined. So that's what we were trying to do with the ICD-10. Now we look at, it's not just, whatever the chief complaint was, got the code in ICD-9. Now we look at, was an acute or chronic problem. So back pain today, was it something that happened today? It's acute and new onset, or is it chronic and they've been dealing with this for 5 years? Specific location anatomically is important to ICD-10. So they want to know exactly what part of the body are we dealing with. Treatment outcomes, they might not get that from your report, but they will get it from the follow-up reports at the hospital based on your initial presentation to the patient. Then they'll build on that to add more to the code for what the outcome was there. Presumptive diagnosis comes into play as far as that code is concerned too. So, early, if you've been doing this a long time, way back in my career, they said, we don't diagnose, we just, treat the symptoms, we go. Well, we've learned now over the years, we've adapted to, we really do have a presumptive diagnosis and we treat that diagnosis aggressively. And then all of these ICD-10 codes are tied to Nemesis 3 at the state level. The collection for the data for every call is tied to Nemesis 3. So this is an ICD-10 example, so you can kind of picture what I'm talking about here. They're developing this, 7-digit code based on these descriptors. So instead of just saying a broken arm, where we would have found that 3-digit code in ICD-9, now we've got to build a code and tell more about the arm. So what type of fracture it is, this one we're going to say is a green stick fracture. Where was it? The shaft of the radius on the right arm. So they're taking all of those things and breaking it down into a category, the anatomic site, the severity, and then the extension is going to be what the outcome was at the hospital, that they confirm the fracture, was it treated surgically or just was splint or cast, and they're going to build this code to be billed. So does it make a little sense there? As we evolve into those, more codes, then there's no more. We saw we dropped off. We are no longer going to get that reimbursed. If we do just the most minimal things on documentation, we're not going to get reimbursed. They're going to get kicked back. A lot of these issues with audits and things like that have been fixed by using billing companies. Early on in the 90s and early 2000s, a lot of agencies were still billing their own, had in-house billing, or you had the lady in town that billed for the doctor's office successfully for years, and she's going to, navigate the fire and EMS ambulance billing for you and do that for a few more decades. So we had to get rid of that because there just wasn't enough education for them to keep up with all of the changes. So now we have billing companies that are out there that specialize in fire and EMS billing. They're often a good mix of financial and billing experience personnel plus staff that has field experience, paramedics that are billers that are in there and know both sides of the fence. This offers a lot of protections against those audits because of their expertise. So they know how to head off those things. They watch those ratios for us and quarterly visits and let us know where we are in our reimbursement levels and on our, ALS, BLS ratios, so they can kind of see any red flags before the red flags get to CMS. So they also keep us up to date on CMS guidelines. They sort out all the information, disseminate only the important stuff. So we don't have to sit through CMS, reimbursement conferences anymore at, nauseum. So in the years that I've been doing QA, there's three types of documenters we've identified. So this first, provider A, should be very proud of their knowledge. They really take the time to use all of the medical jargon and terminology appropriately. They really flesh out everything on a very high level of descriptive terms. So a patient has acute trauma to the left side of the buccal mucosa with an 8mm horizontal laceration at the occlusal plane with displacement of the left central and lateral incisors with a class 1 hemorrhage. So that's provider A. Provider B, the patient has trauma to the left side of the mouth with approximate 1/4 inch laceration to oral mucosa. 2 front upper teeth are dislodged. Bleeding is controlled with direct pressure. And then we have provider C. Patient got busted in the mouth, 2 front teeth knocked out, bleeding from the cut inside his cheek. And I read this always in my 17-year-old's voice, and I feel like there should be a dude in there as well. But, this is where we want to be. So, provider B, somewhere in the middle, this is where most of us land. If you want to aim for provider A, all the respect to that as well, educating yourself and using terminology. But we need to be in this provider B area to some degree. But provider C really shouldn't come out of our professional EMS documentation. So we're always trying to get in the middle here when we're addressing QA. When I do read charts, I don't really, we don't bash anybody's style. We let you still have your own style. We want everybody to be individual and where your comfort zone is, but we just want you to add elements that kind of, square them up a little bit and make them more professional. So A, B, C, try and land in B. So chief complaint is the most important start of the EMS documentation after we establish scene safety and, why we're approaching from the 911 call. But the chief complaint is a collection of what the patient tells you about why they called 911. We want to avoid vagueness, show your medical training, use words like hemorrhage versus bleeding. Instead of flu-like symptoms, we want to say malaise, nausea, vomiting, fever, really spell those out instead of generalizing them too much. Dispatch reason, though, sometimes it's not necessarily the chief complaint. And over the years, that's what I see as the chief complaint a lot. So what would we call this, if we were saying this was the chief complaint? A car into a building. But is that really the chief complaint of the patient? So that's the difference. Dispatch reason, if they call and say it's chest pain and that's how you get the call, that's okay. But the car into the building is not the chief complaint. And we still have people trying to make that the chief complaint. So we really want to identify really what is the chief complaint then. Does anybody want to jump in here? Feel free to interact on any of these if anybody's willing to. But we don't see the patient. We can make up anything else, right? So we can have loss of consciousness. We can have, any sort of injury would be the chief complaint, but the car into the building is not. So we want to expand that chief complaint. That code that we're trying to build, that 5 to 7 character code to communicate to the payer what was wrong with the patient, it really needs a sentence. The cliff notes of the call summed up in one sentence, but not just 1 or 2 words. So this is where I had some, people that have gotten upset in the past and wanted more money and a lot more things that they had to write the sentence versus 1 or 2 words. But we really need to evolve with that to be able to provide the payer enough information to get this paid.
Hey, Renee.
So
it's
here's
Matt.
one. Yeah. Yes.
It's Matt. I remember always being told to, in the chief complaint to always try to have it in the person's own words. If they can verbalize, in quotes, in the patient states, I fell asleep and crashed my car into this guy's living room, or, man, my neck hurts.
Yes, that's
Just
a very common instruction in a lot of people's experiences, and we still see that a lot, and that's okay as long as it sums it up, their actual problem that can be made into that character code. You see the difference there? Before we didn't have to build that code with that chief complaint. But the quotes now, and I'm going to talk about that in a few minutes, we still want those quoted statements or utterances from the patient, but we can put those in the history as well.
Okay, thanks.
So, but again, this is just national standards, a national outline of things that we may see. Nothing is mandated yet. Everybody's still got their style of just putting these things out there to think about for the future, or as you maybe learn something, anything through this whole presentation that maybe makes you think, oh yeah, maybe I will kind of add some of these parts in. So this one is a good example, and I'll let anybody jump in here. What's the chief complaint here?
I'll try.
I'm gonna start picking people.
I'll try.
Go ahead.
I would say chest pain due to a laceration to the left side of the chest.
That was very good. That's really good in expanding that. So the old standard would have been just stabbed in the left chest or stabbed. They might not even have put the left chest in there, but now, we can expand it, and you did a good job with that, at least identifying a location. And here's like a little bit broader, like a deep multi-layer laceration, approximately 7 inches in length to the right anterior thorax, bleeding controlled. So this is kind of what we're getting at. I know it seems like a lot compared to stabbed versus this. We're not asking anybody to carry a tape measure around, just an eyeball approximate length and location. But you did a good job starting that off by adding in, where the location was and what we were seeing. So can you kind of see the difference there? So here's another one. What's the chief complaint? This is a calf, I think. So the old standard. Anybody want to take a shot at redescribing that using the newer concept? So we would have called this a dog bite. I think it
Should be puncture marks to the calf.
Yes. So, and that's what we're looking for. Multiple puncture wounds too. What's the anatomic location? What's the quantity? What's the depth? Is the bleeding active or the bleeding controlled? The source is bitten by a large breed dog, but dog bite is not enough to build that code. How about this one? The old standard, just chest pain, right? The big one. I'm dating myself if I watched this live or any of you else did. How else can we describe that now if we added other things to it?
I can try again. You would maybe use how the patient describes it: chest pain radiating or squeezing, pain, radiating, where it radiates, the like quantity, if they say it's a 10 out of 10, anything like that?
Absolutely perfect. Yes, that's exactly where we're going with it. So this is not a whole description for one chest pain call. This is all the possibilities that we could use to add on to that description. You know, was it dull? Was it severe? Is it crushing? You know, substernal, epigastric, where is it at? Did they have the radiating pain, or any associated symptoms are important too. So that would build onto that chest pain call. Nausea, vomiting, palpitations, pallor, diaphoresis, decreased level of consciousness. Other cardiac symptoms like, you know, weakness, hiccups, feeling of impending doom. Those are all things that can be built into that code. So you might not necessarily use all of these, but you could pick out 1, 2, 3 of these things to build that chest pain description out into that sentence. Yeah, good job. Thanks, Lauren. Any questions about ICD-9, ICD-10? And what do you kind of see why it matters a little bit when we're trying to build that code to make sure we're communicating to the payer, you know, what exactly we were dealing with that chief complaint.
What's nice about the electronic PCR is that these codes are based in the spot. So when you do chief complaint, it's usually a drop down. So you can get your chest pain, your shortness of breath. So the EPCR is helping the administration or the NEMSIS build this code versus the agencies who are still using paper. So the nice thing is, like Renee said, that when you get you know, specific and you kind of not generalize it, but put it in that region, then we can kind of like, you know, expand on this, and it generates very specific codes, and it works very nicely. And you can actually pull data,
Yes,
and I think Renee will talk about that, where, you know, chest pains and then ischemic chest pains and then, you know, non-ischemic chest pains. And so it's pretty cool with all the information you can do with that.
Yeah, we're just, we recently just switched over from one to another and just starting to flesh out the reporting that's available. And it's really just, it's huge. It's great how much there is available now. So narrative formats, after we talk about chief complaint, there's different formats that we've used over time. SOAP was more with the written, subjective, objective information, then our assessment, then our treatment plan. Cheated has been used in some of the earlier development of the EPCRs, where they use the chief complaint, history, the exam, assessment, treatment, evaluation, effectiveness of the treatment, disposition. D-chart is more common. So the programs that we're using now are mainly in the D-charts format, and we'll break that down a little bit. So D is the dispatch reason, you know, why did they call 911 and how was that interpreted and given to us? Chief complaint, what we find out when they got there. The history of the chief complaint, our assessments, and then the treatments, medications or treatments, and then exceptions. So history, we really want to include both the history of the present illness and past medical history, but past medical history only up to what is relevant to today's complaint. We still will have a history later when we get our meds, our sample, you know, meds and allergies and all of those things. You'll have a list of their history. But in the history of present illness section, we only want to have the pertinent medical history. So if it's a back pain call today, you know, they did fall, but they've had chronic back pain for 2 years, that would be relevant to today's call. So you want to keep that brief. Usually we want that to only be a few sentences, because the doctor or whoever else is going to read this at some point, you're going to lose them if you make it too in-depth. And I've got some examples of that later. So sum it up briefly, but include pertinent information. Here's where you can include your mnemonics. Then after this is, you know, your OPQRST, your sample history, your MOI, and your AVPU can all go in here as well in the history. This is where statements made by the patient or bystanders that are pertinent to the injury or illness should be documented. Use quotation marks when they're documenting the patient's own words. You know, I've had chest pain, or, you know, whatever their complaint is. Excited utterances may be important later. So if somebody screams, "Johnny shot me," whether it's the patient himself or, you know, Johnny shot him, those should be in there in quotes as well. Those might become real relevant later, a couple years later, if you ever have to go to court to defend this chart. The next section of D chart would be assessment. So our first step is going to be our primary survey, ABC, neuro exams, A secondary survey head to toe. It is important to document your attention to every body region with this. So when we do the, when I say that, the important to document your attention to every body region, a lot of times on the secondary survey, we'll focus where the localized injury is, and not really go on to everything else. And one instance that I know this came up, I knew this case personally. A patient had fallen down some stairs. She was alert and oriented for the crew. She had a arm fracture with obvious deformity. She kind of grabbed onto a shelf or something and twisted her arm. So they were really focused on that, air splinted, treated that completely appropriately, and documented that localized, focused assessment of the arm. Later, that same patient developed a head bleed. Well, during the fall down the stairs on another shelf, she had hit her head. And so they came back with the risk management to look at the full chart, and there was no mention of that head to toe. So in a secondary survey, if it's an incident where there could be more than just that localized injury, you really have to give attention to it. Even if you say head, normal head, unremarkable is a good one. Every place else on the body is unremarkable. At least give it that attention so that later, if they ask you, you can say, yeah, it was normal at the time. We did not see any injuries to the head. We did not see any injuries to the toes. So again, back to if you didn't document, it didn't happen. So it would look to them like you didn't check the head, but you probably did, but you're focused on the obvious injury of the arm. She was presenting normally. She wasn't showing any head injury symptoms, but I would rather say that the pertinent negatives of a head exam now than to find out later, that there was something. So once we do the primary assessment and the secondary, then we can go into that focused exam more related to the patient's complaint. These exams help support the medical diagnosis, our rationale for treatment, our decisions, and guidance for protocol compliance. So we should not fail to document good assessments. This may lead to questions regarding the appropriateness of the care. So we want to make sure that once we do those exams, we document them as thoroughly as we complete them. The last part of the assessment section is vital signs. So CMS actually requires like 2 sets of vital signs, initial and then at least 1 repeat vital. But we all know that, if the patient's critical, we're going to do them more frequent every 5 minutes or every 15 minutes if they're stable. But for billing purposes and CMS, to make it a valid transport is at least 2. So your initial findings and at least 1 repeat. And we can set up, I think, charts now to even require that most of the time. We've expanded beyond the original, 5 vital signs or things that we might have taken because we have better tools now to do that with. So pulse, we want to document the quality and the rate, respirations, the quality and the rate, blood pressure. I always, when I'm teaching young students or new students to EMS, that, a manual blood pressure first is really prudent. And then you can follow up with your auto cuffs later to get your trends. Sometimes that's not possible or they're pretty stable and you go right to the auto cuff. Nobody's really judging that too harshly, but it is a good behavior to do a manual blood pressure at least once on the call. Pulse oximetry, we're using, but then we're seeing capnography become more important for that assessment of the respiratory patient or the cardiac patient. BGL is something that we are doing more routinely now, not just with diabetics, so altered mental status, things like that. We're checking BGL. Temperature assessment became even more important with the COVID pandemic. We were taking our own temperatures, the patient's temperatures, our family's temperatures. So we have multiple thermometers now in every squad and in every bag. So that's become its own vital sign. GCS is important, and they'll definitely want that if you have a trauma or something that you're requesting, maybe a trauma alert or something at the hospital. That's one of the questions they're going to ask you. And the other night when they talked about having that maybe 30-second EMS report, when we're transferring care, GCS is probably going to be a vital component of that. And then pain level and scale, which scale are you using? If it's an adult, the 0 to 10 scale, or if it's child, the faces. We want to document the initial pain level, and then later on, make sure to document it one more time after you've given pain meds, especially, so that we can see any changes or response to that pain medicine. Things that we also want to include is statements about how and where you found the patient upon your arrival. Scene details are important. We've actually built in here like a generic outline of the narrative. So we want them to have a scene description first, then the past medical history, then, you know, anything else relevant to their treatment. So that's very important, especially a case that might not come to court for, you know, a couple years down the road. You really want to be able to paint that scene for yourself well in your documentation. PTA intervention should be documented too. We get handoffs a lot from, you know, like BLS squads or BLS first responders. We want to make sure that we document anything that they did too. So in the what that was done is just as important as by whom. So make that very clear. ABC Fire did this, you know, XYZ ambulance did that. So throughout your report, it should be very clear who did all of the interventions or gave medications and things like that. Both positive and negative findings and responses the patient has to your assessment, such as the presence of or lack of pain or sensation. Those are important. Sometimes we forget those. We do the head to toe. It's unremarkable, but you know, we want to put in those responses to your assessment as well. If you're pressing on a limb or pressing on their belly, you know, what was their reaction? Now we'll get into the treatment. So we want to document treatment on the scene or PTA. So again, anything that's reported to you on your arrival that's been done already. And then anything that we do, the stay and play, you know, document that. And then any interventions and treatment that we do en route should be like the next section. The documenting of who and when for each intervention, though, I can't repeat that enough, along with the patient's response to the intervention is very important. When we look at this from the legal aspect, that's what they're going to want to know. So it can't just be general that, you know, EMT gave, you know, an epinephrine pen. Who gave it? Like, who was the one that did it? When did they do it? So we want to make sure, not necessarily naming, you know, full names, but medic so-and-so gave, you know, the meds at this time. Also on moving patients, that's important, especially when we have multiple agencies responding to a scene. You want to say, you know, ABC Fire and XYZ Fire crews assisted patient to the stretcher and, you know, whoever did what from there. When we're giving meds, we want to document the time, the dosage, the route of administration. We've all learned the 6 rights of medications, right? The lot numbers for any, especially narcotics, that'll be required probably on the paperwork you need for the pharmacy later. So those are important. Documenting the patient's weight converted into kilograms, that's important too, because we use a lot of weight-based medication. So that should be somewhere in the chart. So whoever is reading it later can go back and say, okay, she weighed 56 kilos and this is what they gave. So you want to make sure that you don't forget that component. I have some providers that do it under the patient demographics, but then they do it again in the narrative portion for that, you know, narcotic specifically, if it is a weight-based drug. Results of procedures like 12-lead interpretation of normal vitals or blood glucose should all be documented. Repeat pain scores, as I mentioned before. And then we need to document our failures, such as IV attempts, intubation attempts. If we don't learn from the failures and only mark our successes, we really won't evolve much further than we are now. Plus, you don't want to bring a patient into the ER that has, you know, 6 holes in them, but we only have 1 successful IV. So we want to make sure that we show those attempts even if they're not successful. Transport or transfer in the D chart, where you transported the patient is important. Any chart changes in the patient's condition during the transport, and then to where and to whom you release the patient. So for continuity of care or transfer of care, we should document those. That should be kind of summing up towards the end of it, and that a report was given verbally or a copy of a written was given, whichever your service does, but we should document that transfer of care. Exceptions for the end of the D chart narratives is anything that delays you getting the patient to the hospital. So if it starts from the time you leave your station and you hit a train or the weather is inclement, if you get on scene and you have extrication issues or prolonged extrication, or if there's a dog blocking your path to the patient that needs to be handled, you know, if you're waiting on police to secure the scene or to come with you to the hospital, any breakdowns or, you know, ambulance wrecks, anything that would delay that time between time of call and the patient arriving in the hospital should be documented in the chart. Now, a lot of the EPCRs have that. They have a whole section where you can just check box those things. You don't have to write them so much anymore. Any questions so far about narrative styles or anything like that? All right, so these I like to call documentation pearls. It's just a bunch of random things that have been compiled over years of reading charts that matter. So good documentation is accurate, it's precise, it's comprehensive, it's legible, objective, timely, and unaltered. So readability in a chart is very important. One for your QA person, one for the lawyers that might look at it later. You know, we wanted to have good readability. Before we sit down to chart, we need to have a plan. You know, which of those narrative styles are you going to use, or how are you going to document this run? Most of us, I think, develop our spiel or whatever we're going to write, and we just change the values for each patient. Mine in the rundown is pretty much the same every time I write one, but I just change out the information for that specific call. We're painting a picture, though, that we can remember this chart 5 years, 8 years, 9 years down the road. Most of the just MVAs and stuff, I think that's like a 2-year window. But anything that's like an arrest or might linger in a trial, those can go on for years. Pediatrics can go even longer, and I'll talk about that a little bit later. But so we want to paint a really good picture to trigger those memories of that call for us, and to be able to detail, recall all of those things that happened. We only want to use accepted terminology and abbreviations. I see this a lot where we just kind of make up our own thing, and your partner might be able to read it. Your boss might be able to read it. The doctor, medical director might be able to figure it out and interpret it. But would a jury or your peers be able to figure that out? Or the patient, if they requested their own report, would they know what that means, or their family? So we need to make sure that we're using only accepted things. I think most people would understand O2 or IV, but a lot of people might not know NC for nasal cannula. And when you don't use the terminology, or you make up abbreviations, it's going to get you a lot longer time analyzing that report, like on a witness stand, because they're going to want to clarify everything you meant by all of those abbreviations. So we want to make sure that we're, not using them, spelling things out more often than not. Google, if you're presented with a medication or illness that you're not familiar with, look it up. Look it up so you document it correctly. Maybe you understand it the next time if the patient is going to be a regular in your area. This is especially important with like medically fragile kids. Their parents can rattle off things that I've never heard of, but I always try to look them up so I'm familiar if I go back there again. So definitely use Google to your advantage. So spelling, sentence structure, and phrasing, they do matter. And this is where I get a lot of people unhappy about, talking to them about their spelling or sentence structure. And punctuation is also important, excuse me. So you can see the differences there. Let's eat grandma, or let's eat grandma. So if we don't use the right, punctuation and spelling or grammar, it's going to change the way the sentence looks. And I'm going to show you some examples of those. As we go through the next, 8 or 10 examples, they're actual charts. All of the identifying information is obviously removed from them. Some of them are from charts that I've QA'd, and then I have a group of other people that do QA also that we share them with. They are not meant to embarrass anyone or hurt anyone's feelings, but they are to learn from. As you're going to look at these, I want you to look at them from the jury pool. Look at them from what they're going to look like from the outside for somebody that doesn't know or won't recognize it. You're, like I said, your partner, the medical director might recognize it, but the layperson may not. So kind of view them in that aspect. And then if it is you, or you recognize yourself, or you recognize the situation maybe that's in it, nobody knows that if you don't tell on yourself. So there is nothing identifiable on it, but we're going to go through a few of them just to give you ideas what I'm talking about or why it matters. So this one of my all-time favorites, I think, syncable episodes. Anybody out there can probably throw out what he was going for, but what does it look like when you know what it should be? So syncable episode was probably the intent, but when we see that and then we blow that up on the big screen, then you start to question maybe some things about the chart. Or does it give you any kind of feeling like that at all? You know, spelling errors, they can change words, they can change the, you know, the meaning of things, or they can just look careless. And one of the reasons this is happening, this is a good one to point this out. So when you do cap lock on a lot of the EPCR programs, it automatically shuts off its ability to spelling correct, to autocorrect the spelling. So if you do in, you know, lowercase and then just with capitals at the beginning of sentences or proper nouns, it'll still do spelling correct. But when you do cap locks, it shuts that off. So if you have challenges spelling, this might not be the way to do your charts. So this one is another example. So patient was holding her puffer. From a medical professional standpoint, how else could we have maybe phrased that?
Rescue inhaler.
Yeah, definitely. You know, rescue inhaler, MDI, multi-dose inhaler, you know, something that is a little more medical professional to explain what this is. Because now if I have to explain this and a jury asks me what I meant by this, you know, I've got to go into a whole nother explanation. Makes sense? So this is a one that's just like not even a complete sentence, really. Meds you don't remember for a current medication list. You know, this one, these kind of things don't make us look like professionals. We need to have, you know, better structure to make that look professional when they're being evaluated by people outside of our business. This is just some more spelling errors. Defibrillator is firing. That was the chief complaint. This one was just some choice of words, like was grabbed. I think they're talking about the stair chair was grabbed to assist with removing the patient from the, you know, wherever. So what else could we have worded that in a different way to seem more professional? Or is for people fine with that one? So patient has bilateral leg swelling with sweeping. So I think they were going for seeping here, but this changed the whole meaning. And again, to us, it's probably you can figure it out. But to somebody that doesn't have any medical knowledge, they're gonna want more clarification on what that meant. This one maybe could have been handled better. I think quoting like whatever the mom said, the angry and punched with the misspellings wall to let off steam. Mom is afraid he's going to hurt himself. So the sentence structure itself would be better if it was just quoted and however the mom was explaining it, I think, on this one. Any feelings on that or thoughts on that? There's just some other spelling things that kind of change or make them interpret what we're talking about there. Decorticate posturing is what we're going for, but without the autocorrect picking that up. Left funny pain. So I thought that one was cute, actually. So the funny bone, but humorous, of course, anatomically is spelled a little bit different. This one, no foul play like waterfowl. This one patient, he felt a little bit woozy, but state something. So, but this could have been a quoted sentence. If he said, I feel woozy, it would look better than the, you know, the provider describing it as feeling a little bit woozy. So does that make sense to change up the way we document it? I'm sure this is probably where that came from. The patient said it, but then if we write it as we're saying, it just takes away from that medical knowledge and professionalism. This one I love. Patient has large amounts of dried green snot on face and nose. Like, just no, I don't even want to read that. But we can find better ways to probably describe that. This one was more in the patient states list is at home. So current medications, this happened a lot until we really started telling people not to do that. We really shouldn't do this. We should get the list of medications. Some of them may affect our treatment, and it may be something the hospital needs to know quickly that will affect their treatment. So don't generalize this too much. If we can find, go the extra steps to find the medications or find the list. We just randomly found a vial of life. They had a note on their freezer just a couple weeks ago that said vial of life in the refrigerator. If you've been doing this a while, those were given out probably 15 years ago, and it was completely filled out with their current meds and their doctors and their living will and everything was in there. So if you take a little bit extra steps, or somebody on your team can take a little bit extra steps, even the police have gone back and got us the medication list or bottles, but this is not really prudent to do it just this simply. We want to get that actual list. If they're on blood thinners, that might matter if it's a trauma. There's other things that can interact with things that we're going to be giving.
The thing about that, Renee, that I want to point out is that, there are different software vendors out there, just as EMS, for in-hospital patient care too. One of the large ones that I know Cleveland Clinic and Mercy Health use is the MyChart system, the Epic MyChart system. But then when you go to a Steward facility, or maybe you're going to an outside facility in a different part of the country, they don't have the Epic. And I know that Epic works really well and intermeshes together. So it's very important that, for example, if a patient is to a hospital A and they're not a cath lab, but now you bring them to hospital B and it's completely out of this hospital system, it's important to get those medications, because if not, that nurse is going to have to make a phone call to that other facility or maybe to the primary care physician. That's going to delay some care as well. But I just wanted to point that out.
Absolutely. Thank you. So then this is a total opposite example. When I talked way back about history of present illness, and you may not even be able to read all of the detail here, and it's really not as necessary as just seeing how much detail is there. So this history of present illness is, very, very, very detailed, and it actually goes from the patient contact all the way to back to their station and, recalibrating some of their equipment. This is not necessary for history of present illness. The first few lines should be able to sum up what exactly is going on. You're not going to get a doctor to go past, very far past those first, few lines of summing up what exactly the problem was in this section. So, and what I love about these new EPCR programs is they build this narrative anyways for you. So it might not be this big paragraph anymore. We don't need that, because you're building your narrative in all the different sections by filling out everything that's required. So something like this is probably outdated and maybe a little bit too much information for anybody to even digest in a quick amount of time. But then these med lists, that, this is good. This is very, good history. This is obviously a patient that has a lot of things going on, and good documentation of the meds and allergies. So I'm not saying this is, this is actually a smart provider that really could talk at a higher level about the care, but maybe just too much. Anybody have thoughts on that, or anybody, how do you feel about the narratives out there now? We don't have to write them as much, I think. Or Larry, what do you think on the inside of the hospital? Are they going to read something like this?
Yeah, nobody's going to know. I'm not going to read this. No nurse is going to read this. A doctor's not going to read this. And I know that interventional cardiologist, if you say this is what's going on, he's like, I don't give a shit. I need to know what happened. So this is too long to read, especially with the hospital offload times that we just talked about. If you're giving something, you've lost my interest, and I think you've lost a lot of other providers' interest too. So imagine now that you're an outside agency backing up somebody else, and you've got to get their run reports to try to figure out what led up to you. Would you really want to read this to figure out, okay, well, why did they call Larry the paramedic to come and back me up? There's a lot of stuff in here that's not necessary. And I think when I read this, they already said EMS is already behind the 8 ball. Those are, sometimes you can be a little too wordy, and those words and extra fillers in there are not necessary, number one, but number two, can get you caught up in a lot of legal stuff, because then, I think if Chip's still on here, but then what does already behind the 8 ball mean? And that's something else to consider. Obviously, when somebody calls 911, we should already expect to be behind the 8 ball, because the mechanism of injury happened or the illness has already happened. So I think that's a given. But yeah, the actual typing out of a EPCR is going down because as we build the event log, we're documenting the time, like for example, if you give fentanyl for pain meds, in there it has, was it improved or not? And then the vital sign for pain came down from an 8 out of 10 to a 3 out of 10. And were there any complaints? So you do check boxes versus 100 micrograms of fentanyl was given, pain decreased from 8 out of 10 to 3 out of 10. Patient had no side effects, and it really saves a lot of time with these electronic healthcare records. But if I was looking at this, or I know if any of the colleagues are looking at this, or even me backing up somebody else, I've lost my interest and I'm not going to use it.
Absolutely, agreed. So good example of not necessarily what we need. So the next two is just about that structure and that readability. It's so important, especially if you're starting a QA program. To get through the runs, they got to be readable. To get these through a courtroom, they got to be readable. This is still happening out there. So if you try, just looking at this is overwhelming to me right out of the gate. There's no, capitalization. The punctuation is inappropriate. Way too many, short little abbreviations going on. Some made up, some not. But, I can read this because I've seen this over and over. So patient complains of chest pain times 1 hour, patient's ABCs intact, ANO times 4, vital signs stable, patient loaded to cot and moved to squad, O2 IV monitor, CPAP transport to ABC hospital without incident care and transferred. And that was the extent of it. This is about a week old. This was the extent of it. But when I see IV monitor, CPAP, things like this, there's a lot more that was going on with this patient, and we should have used a lot more of those check boxes and a lot more evaluations. I couldn't find a chest lung assessment for this patient. He went on CPAP without really reporting any breath sounds or assessment of that. So this is what we don't want. This example A, that's just way too simplistic. My probably 7-year-old nephew types like this on his iPad, and we need to do better. So sometimes these people, if we can't get them to just at least capitalize this P or capitalize this, proper noun of the hospital, they might go to the cap lock, because it's just too much effort to not capitalize a few letters here and there. So cap lock then for them probably works. But most people like, just writing with proper grammar, sentence structure. So this is example B, saying basically the same things, but just a little more clear. If you had to read this one on a jury stand up on a big TV versus this, I'm not saying this is the absolute way it needs to be, but this is a shorter narrative in an EPCR where all of the other checkboxes have been filled out. All of your assessments are done. You can just sum up the basics. They had chest pain for an hour. Their ABCs were intact, but we spelled out what they were so nobody had to guess. Patient presents conscious, alert, and oriented, and to what? Name, place, time, and events. This did not take much longer than probably this did, honestly. If this is your spiel every time and you just fill in the gaps, you can type this in, seconds. We put who moved the patient to the stretcher and placed them, what kind of position, secured with straps. This is important. This is one that's come up in a lot of discussions, especially in the ambulance safety ones. So there was an incident of an ambulance company with a newer cot that had a set of 5 straps. And they were documenting, that they had 5 straps on the patient. They got into an accident. They actually only had 3 straps on the patient. They had removed the shoulder straps, the harnesses that come over the shoulders. In the accident, the patient went headfirst off of the cot, through the bulkhead and out the front window of the ambulance. So be careful that when you document the straps and the number of straps, that they are the right number of straps that should be on your cot. I know a lot of services have problems with that, people taping them up or rubber banding them up or not using all of the straps that are designed for that cot. But that also takes away any responsibility the cot manufacturer would have in that situation. So just carefully document. It's more generalized, secured with the appropriate straps, or but counting them and then having the wrong count is not a good idea. Patient moved to the ambulance loaded without incident. That's kind of a standard line that a lot of people have used over the years. An ALS assessment completed by the paramedic. That's an important one for the CMS side of things. They want to know that an ALS provider assess the patient. That doesn't mean you can't downgrade it to BLS based on your findings, but if you're an ALS ambulance for an ALS service, then you need to have the paramedic document they did that ALS assessment. And this has been a while requirement. And then you can document, though, why you downgrade it to BLS and handed that off to maybe the EMT or the advanced EMT. The line C event log for further assessment and treatment details. Now they can go back to that page and all of the details are there. I don't need to reiterate those all on this narrative. I don't need to have a head to toe, assessments like the old way, because now I've checked all the boxes on that head to toe previously. Patient transport to ABC emergency department without change in status, care transferred, verbal report given to the ED at RM bedside. That's just prudent. We took them where we just, were intended. They didn't get any worse on the way there, and we transferred care with, ED staff in attendance there to take over the patient. So much cleaner, much less to interpret for anybody that's not in this business versus this where there leaves a whole lot of questions. A few more pearls, fill in all the fields when we're using those EPCR programs. I've heard every pre-hospital director that I've been in contact with. We can't get the data if we don't have the fields used. Now we can force a lot of those fields, which is great because we can control, what we're getting back for the data. Beware of any default buttons or autofills though. Don't use those just very quickly without really reading it through what it's actually putting in there, because it might contradict something else that you put in an earlier page of the chart. So be very careful of those. Record accurate date and times that, usually you're basing that on the CAD or whatever comes from dispatch. If you're not, most of us are not keeping our own times for the initial part of the call, but once you get into treatment, you really should use those event logs, event buttons on the monitor to put in medications or when, interventions were done. Some ambulances have a whiteboard with, a dry erase board that you can write down those times, but that part of it is your responsibility. So don't try to guess through those, especially when we're talking about medication deliveries and time. And you can probably remember just, as recently as your last day of giving a report in an ER, what time did you give the last epi? What time did you give that, fentanyl? That's important. So make sure that you're recording it accurately. And then it's attach and scan any supporting documents. Now we do have EKG import on most of the products out there, so it'll automatically, we can upload those and pull to them. But if you don't have that capability yet, attach your 12 leads to the paperwork as well. Use those EKG imports. Those have really made a difference in our reporting of intervention times, transmitting EKGs, recording to the EPCR. If you had multiple recordings, note why, trending or worsening findings, the patient moved, noise, so you repeated it, just say why there's those multiples on there. One of the important things when we go back to CMS, 12 lead interpretation by a paramedic is required if that is going to be an ALS charge submission and we're going to get reimbursed for it. So it has to be documented. Some of the newer programs have an appropriate checkbox, interpreted by medic. So make sure that that's stated in there somewhere, or you do check that box. The basics can put on the 12 lead, they can transmit the 12 lead, but it has to state the paramedic is the one that interpreted it. Document objective facts and your presumptive diagnosis based on those facts, but don't fear documenting what you suspect. Internal bleeding, head trauma, chest or abdominal injuries based on the finding. We go back to that very first picture of that laceration, to the abdomen, we can kind of guess what's under there and we can suspect that there's injury to those organs. So don't be afraid of documenting that. Again, auto narratives, they're efficient, but they're very restrictive. Just make sure that they don't contradict any part of the patient's record. Location, location, location. Review those body regions, the planes, directional medical terminology that clearly identifies findings. Excuse me. So that we can describe those very well when we're describing the location of those injuries. A couple of pediatric things that are important. Imagine you're testifying in front of the grand jury, but now it's 9 months or 9 years after the run. That's because our pediatric patients has until 1 year past the age of majority or their 18th birthday to file a lawsuit in the state of Ohio. So when we think we can discard records, after so many years, pediatric records are not the same. They can go on for, almost 2 decades. So we need to really do a good job documenting and painting that picture for yourself. So if you do have to go back to that at some point, you can remember that call. Abuse and neglect, just some things about documentation. Again, don't be afraid to document your suspicions and your findings. Be very specific in describing markings or abnormalities. Use medical terminology and anatomic locations. Finger pad bruising patterns on the gluteal region, circumferential bruising to brachial region of the arm. Those type of statements are very important when we're painting this picture of this abuse. Bruising to the helix and the pinna versus bruised ear. You know, we want to make it very, very strong and professional. Some of these cases are probably the longest time I've spent ever documenting cases, and they will take a long time to come back. One of the worst ones I had, I remember sitting while I was documenting 2 or 3 hours, you know, making sure that I got every single mark and, you know, as much information as possible. And I never saw anything about the case for another year before they even arrested the suspected abuser. And that was another 2 years of continuances and, you know, all of the legal process before they even looked at that report. So you really want to take the time. One of the things I've heard from forensic pathology by their request is avoid using multiple bruises in various stage of healing. They think that's their job. And, you know, they go to school a lot longer than me, so I'll let them have that one. But what you can describe is the size and the color. 1 inch round, dark purple, blue bruise. You might know that that means that's fresher than this one that's green and yellow, but, you know, their pathology training teaches them what is the exact stage it's in. So they would prefer to see it like this. Crime scene documentation, same thing. Be very specific on locations of patients, weapons, blood patterns, bystanders, odors, etc. Paint that picture. Again, it could be a long time before they get to that document. You want to know, you should document who went in and who went out in their entrance or path doing so. Document any movement of furniture, items, or other bodies when necessary to access a patient. Document specific wounds by size, shape, body region, or any residue or burns, but avoid the use of entrance and exit. Again, leave that to the forensic pathologist, and again, that's by their request. So they do not think that we can identify that without some more scientific information. So they would prefer just showing the type of wound, the size of the wound, the shape of the wound, if there's residue or burns, but avoid saying that those words entrance or exit. Patient signature forms, just real quick, because you probably ad nauseum heard those, but they are the absolute standard. We have to have them. You probably have somebody in your agency whose job it is to chase those around, and we really just have to resign ourselves to the fact that we absolutely need one every time, or it's not going to get paid. Section 3, the biggest complaints that come up from that across the country, I see this on so many websites and message boards, is Section 3 is for emergency only when the patient is absolutely unable to sign for themselves. Treatment and biohazard are not medical reasons for a patient not to sign. So it's got to be an absolute medical reason, whether it's altered mental status or you know, their injury or unresponsive. But be very careful about using that section. I just saw today a new statement came out from CMS, and there is going to be an option for the provider to sign that section. So if you can't get the nurse or they're busy with everything they've got going on, they are going to allow us to sign that as an affirmation that we brought the patient in, and the patient could not sign. The patient did not have a family member present or a POA present that was willing or able to sign, and we can't get that facility staff member to cooperate, then they're going to allow us to do it, but it's in extreme cases and it has to be extremely justified. And again, I just saw that today in a bulletin, so didn't even make the slides here. So the medical legal, Chip went over most of that, so I'm just going to real quick just pull out a couple things on the documentation part of that. So usually these are greater patient liability in EMS. We have a higher incident of refusal requests from attorneys and the courts than we do of anything else, except for MBAs, I think is the only thing higher incident. So those actually need more documentation. When I talked about going in the, you know, storage room looking for those old papers, we had a refusal paper too that was different from the run report. And if the run report had less information, the refusal had nothing on them. So those ones we actually should be doing more. We need to do more to document the patient's capacity and their right, the understanding of the rights to refusal and the risks of refusal. We should encourage them to go, you know, with diagnostic tests or normal vital signs, EKGs, things like that. Despite the most legitimate reason, they may not want to go, and that's okay. We can't force them, but then we need to document the heck out of it instead of just a basic documentation. patient refusal with all the liability associated with it actually requires more. So they should be asked to sign a refusal when all efforts encouraging them to be transported have been exhausted. So we can even take this to a higher level of care. If it's AMA and you're really not comfortable, call your medical command, let them talk to them, ask for a doc, and when all else fails. And I've done that personally myself. Make sure that you really have done everything you can. So the final part of the refusal is the situational assessment. The patient understands the medical condition, the risks taken if they do not get treatment, and they have the capacity to understand and acknowledge those risks or refusal. So, but we have to be clear when we're speaking to them too. Your chest pain could be cardiac in origin. If you stay home and don't seek treatment, your heart muscle could die. If enough of your cardiac muscle dies, then you could die also. It has to be very blatant to back that up. In this case, I use all the time to show that. This Billy Browning case in 2003, his wife Jewel became sick. His daughter called 911. Paramedics assessed her, telling her she was probably having a heart issue. Jewel still refused to go, and she signed the refusal. An hour later, they were called back. She was in VFib, defibrillated, got a pulse back, but she later died after working her for, I think, 2 hours. The court ruled, though, the paramedics were liable because they did not educate the patient as to the risks of her refusing treatment and transport, despite having signed the refusal. So they just didn't make it clear enough. So you have to say the words that make the most sense and make it simple enough for them to understand the worst risk available. I just got a few more things on a breeze through. I know we're a couple minutes over. I apologize. We can't talk about documentation without talking about quality improvement and QA. These ensure the standards of patient care are being met. They're required by law in most states. We have a tendency to make them reactive. It's getting better, but we really need to have QA programs that are proactive. And by reactive, I mean, something gets complained about, we pull the chart, we find an issue, and then we go, handle it with those personnel. But proactively, we should be looking at all of the charts, and then those ones will kind of jump out when we do find those, but not just putting out the fire once it's already lit. 100% call review versus 100% provider review is usually the two ways that we look at QA. When we're establishing a QA program versus when we have an established QA program, we might do it one way, but when we're introducing a new QA program, we might do it another. So 100% call review, it's just at every call the service runs. And I've done QA for my 900 a year service here. And then I've done it for a service that ran 24,000 a year. So, and that was 100% call review. I don't know if any of you are familiar with Jay Northrup. He is a Euclid officer on Euclid Fire, and he does 100% call review of all of their calls. In the meantime, he's traveling the country teaching people about QA at 400 or 500 agencies, I think. So he kind of, gave me the tips on how to do 100% call review successfully. If you can't get to that quite yet, and you're just starting, you can do 100% provider review, which means you take every provider on your roster and maybe do 10% of their calls in a month or, a time frame that you set. So that may make it a little bit more manageable as you're starting out. You need medical direction involvement with this. So you want to find things at your level, self-reports, and get the medical director involved to help sort out the issues. Peer review, I think, is a vital component to that. Once we introduced peer review, we really started getting so much more acceptance of the QA process. So one of the things that we did was like strips. People would leave a strip on my desk, and every morning I hand it to every medic that walked by. And, what do you think this is? Well, then they kind of started getting really excited about that. You got the strip today. Hey, I got a strip for you. It just puts a lot more talk about things, and then we learn what other people might have done or how they would have interpreted something or what their treatment would have been. So peer review is a vital component to a good QA system and letting everybody feel like they have a part in it. QA, though, should acknowledge the good, not just the bad, and more of the good than the bad. The most effective QA is educational and not punitive. I don't really believe in punitive QA. That just doesn't seem like it's going to benefit our professional service here or our career. Educational, we want them to learn from what we find, but I also want to acknowledge the good. When we first started doing QA, they started getting really surprised to get messages from me that said, hey, good management of that case. That was a tough call. You did a really good job, because they weren't used to that, but we should be used to that. We should hear all of those things, not just the bad things. Remediation and training, individual and groups can come out of that. Remediation training individual means I've identified one person that's just having a struggle with one thing, and we're going to address that with them directly. Group training, though, might come out of our overall, we're 60% innovation rate, as a company. And maybe that, that's a big red flag. We need some continuing education for everyone for innovation. So we want to evaluate all of the data to be able to identify future remediation and training. Trends and evidence-based performance measuring, protocol development, all of that comes from a good QA program. So if we see that we're doing something really well or something's not working, that's how we change it, by having a lot of data to support it. The last pearls, and this is the last slide, is be a medical professional, ask questions, get to the root, document accurately to ensure your credibility, and CYA, cover your assets. Your name's on that PCR, which means it's your credentials on the line. So just really think about that as you, maybe take some of these points or takeaways from this to add into how you document a call. Any questions for me?
Danny Hughes has a question.
Sure.
Do you do this on the side of coming into a company and teaching it?
Yeah, I have helped other places set up programs for sure, and still willing to do that, or even if we do it remotely or give you some guidance that way, or yeah, definitely can do that.
Thank you very much.
Sure. And actually with Trumbull, some of the things that changes we've had going, we want to have a QA committee so we can identify the QA people from each agency and maybe get together, once a quarter, and maybe we can actually learn from each other, or kind of make some changes that we all have kind of, the same concept. So one of the things I'll run into is that, well, they don't mind that I do that at my other service, or, our protocol is different there, so they let me do it this way. So we'd like to, make some unity in those things, and then QA people will be able to share, some of the things that are working and some of the things that aren't. But yeah, you feel free to contact me. I'll put my email up there, or Larry can add it to the class information.
Thank you very much.
Sure. Any others?
Any other questions out there?
Well, thank you for your time. I know this is not the most exciting topic. I hate myself sometimes halfway through it. It's hard to listen to, but I appreciate the invitation to share that. And if anybody needs any assistance in getting their program set up, I would absolutely welcome helping you out.
No, that is a tough subject to teach, but I think you did a really great job at it, Renee. I mean, it's valuable information. My role of QA has changed since taking this job, and I have a different perspective on it now. We QA all the big four: the chest pain, trauma, stroke, and then I usually just pick a spattering of others. And then, I try to either provide feedback through patient follow-up or just, by conversation or whatever. So, there is QA. There's a lot of QA out there, and we all laughed at some of your ones with the mistakes and everything. But I would shudder can you imagine if you were the guy going for your deposition or something? We always talk about your reports blowing up 8 feet tall in court or whatever.
Yes.
But, you're there because the guy died after you gave him ketamine, and ketamine is spelled wrong. Well, if I'm the attorney, the first things I'm going to say is, you can't even spell it.
Right.
So I personally believe that spelling, punctuation, all that stuff matters very, very much.
Agreed.
Any other comments, questions, or concerns out there for Renee?
Renee, this is Sheila Doan. What about your psych patients for documentation? You said your refusals are very important and that your motor vehicle crashed. I was always told that you better document and dot your I's, cross your T's very well on your psych patients also.
Yeah, absolutely. I would agree with that for sure. I had some of that limited because I wasn't real sure on how much Chip was going to get into in his first portion. I knew he was going to talk about pink slips and things, but yeah, absolutely. On the psych, you definitely want very thorough documentation because those can go sideways for sure throughout the call. And then, of course, having the police and the pink slip is very important too. But yeah, good point. Thank you, Sheila.
Thank you, Renee. Very well done.
Thank you.
Nobody else? Well, awesome. Thanks again, Renee. That was very, very
Great.
well done.
Thank you.
Very informative. I appreciate you taking the time out of your evening to share that with us, and hopefully some of these people take some heed to it, take it back to your departments and your companies, and along with all the rest of the knowledge that we've hopefully we've given you. So, looking for the betterment of your care and the betterment of your documentation and everything. So very good. With that, I guess we'll shut it down and we can all see you on, what day is today? Thursday. So Tuesday. We'll see you Tuesday, the last class.
Awesome. Thank you, Matt.
Everybody have a good night. Stay safe.
Thank you, Renee.